Yeah, it has to be a jurisdiction that's proper for that court. But once you, so you have, basically, it comes down to, you get a judgment, you have the court, the clerk certify it. There's your competency anyway. Well, anyway, that kind of is the, that's the lawsuit that we brought against him. So then they all demurred. And basically, all the demur does is says, we agree with the facts, but we're immune from prosecution. Okay, that's really all they said. They put in thick paperwork, but that was it, the bottom line. But I'm going to, after I disentangle from this cord.
They said she was crazy.
Well, they said that too. Right. In one of the papers, they said she was crazy. But here's what the judges said. I'll read it to you.
She studied what? The Constitution? She must be crazy.
Okay. Now, you would think these judges would know better, okay? You would. But remember, what did we do? We said the judges did certain things or did not do certain things, but we made factual accusations, okay? So they came back with a demur. The demur argues the law, basically says, hey, we're immune. We have judicial immunity. And they cited cases that showed they had judicial immunity. But of course, they didn't cite the cases that said that judicial immunity does not exist when they violate a constitutional right, or when they go beyond their jurisdiction, or when they have no jurisdiction. Okay? But look what they put in their demur. This is a quote. They quoted another case, okay? And they said, a general demur admits the truth of all material facts alleged in the complaint. What more could you ask for?
Yeah, right.
This is the judges saying this, okay? If there is a reasonable possibility the defect can be cured, the plaintiff should be given leave to amend. Well, that's if there's a defect and if it can be cured, right? But what if there's no defect? Anyway, if there can be no liability as a matter of law, the pleader should be given no leave to amend. And that was Ramirez versus USAA casualty. All right, but they acknowledge, hey, a demurrer admits the truth of the facts. So we have all these facts in there. Well, thank you very much.
It's like, which foot should I shoot myself in?
Yeah, which foot should I shoot myself in? I was really surprised when I saw that. You know, the judges.
Oh, God, that's a win.
Well, sounds like it to me. Yeah, I know. But they went on to say, it is well established that judges are granted immunity from civil suit in the exercise of their judicial functions. And that's true, if they're exercising judicial functions. But if you never get jurisdiction, that's not a judicial function. And it's also not a judicial function to violate a constitutionally protected right. Otherwise, the judge is putting himself above the Constitution, right? So that's not going to fly. They leave those details out, okay? It says this rule applies even where the judge's acts are alleged to have been done maliciously and corruptly. Okay? Take notice of that. I mean, once the judge acquires proper jurisdiction, then if he misbehaves, you have no protection. Okay? So, but he never acquired proper jurisdiction. It was challenged and it went unanswered. That means he doesn't have jurisdiction. So, anyway, I just thought I'd read that one. I thought you'd get some pleasure out of that.
It's like tax liability.
Pardon? Yeah. Yes. Microphone.
When we asked the public defender about the challenge of jurisdiction, why he didn't challenge jurisdiction while he was trying to go to her defense, he said she committed the crime in jurisdiction, so therefore that gave them jurisdiction. That's their argument.
I see. How
But
nice.
it was the public defender that made her guilty also.
Sure, sure. Well, we've already accused the public defender of colluding with the prosecution. He's not defending. Yeah, aiding and abetting, I suppose. Okay, well, so like I said, the essence of what they were saying was that they have immunity, okay? And every one of the demurrers sang that same song. So, okay, let's get out of that. Okay, so since we're talking about the judges, let's go over to our answer to the judge's demurrer. Okay, where's the judge here? Right here. This is our opposition to their demurrer. You'll notice the format, same as before. You do have this little, right here, you have the title to the paper. The whole idea of the title of the paper is to give a person some idea of what this paper is about. Remember, titles do not control. Okay? So there's no need to get it exactly right. But anyhow, these are points and authorities. Is there anybody who is familiar with points and authorities, exactly what the format is? You got one here. Okay. Points and authorities, that's what they're called. Another name for it is brief. Okay? Of course, as you know, if there's anything in the world that's not brief, it's a brief. Okay? So, but this, it's also called points and authorities. If you really wanted to call it, give it a full descriptive name, you would call it points, authorities, and argument. But they never say the argument word. They just say points and authorities. Now, this is a good example of points and authorities. Basically, you have your caption up above, okay? And then down below, you have this format. And this part right here, points and authorities, in opposition to demurrer of Wiley, Arnold, Ellison, and Sokolov. Okay, those are the four judges. And this is just a general catch-all, so there's no point being made. It's just kind of introductory. Counter-plaintiff is one of the people of California, and in this court of record opposes a demurrer of counter-defendants. Notice that. Same wording as what we put in the action. Repetition is good. Okay? Just slide it through because they can't say later they didn't realize. Whatever they didn't realize. They have no excuse. They're attorneys at law. They're educated in law. We're talking law. Okay? If they're out of their league, that's a personal problem they have. Okay. So you kind of reemphasize it in the little footnotes. I use extensive footnotes when I write my stuff. And we go through, basically, we make our point. Counterplaintiff is one of the people of California, and in this court of record opposes the demurrer of these guys. So now we get into the brief itself. That was just introductory. Now, what you see right here, that highlighted part, that's the point that's being made. When they're talking about points and authorities, this is an example of a point being made.
You want to make the whole thing bigger?
Yeah, we should, shouldn't we? It's not very big up there. Looks fine to me. Okay. Can you all see it now? Okay. This is the point that's being made. Okay. Counter-defendants admit the facts showing they have committed wrongful acts under color of law without jurisdiction, thus breaching their duty to counter-plaintiff. Their demurrer should be denied. That's the whole point of what follows. Okay? Now, normally what you do is you make your point, all capital letters centered on the page, arranged in a way that's easy to read, okay? Short and sweet, okay? And like I said, that's your point. The next thing that you put in is the law or authority, some authority that supports your point of view. After that, you then argue the case. In other words, you say, well, because of these facts, because of those laws, you put it all together, you arrive at the conclusion this way. Okay? That's your argument. So we made our point that they've admitted the facts that were put in, they've breached their duty, and the demurrer should be denied. So the first thing is we bring out the law. The organic law is the constitution of government and is altogether written. Other written laws are denominated statutes. The written law of this state is therefore contained in its constitution and statutes and in the constitution and statutes of the United States. That means federal law applies in California. Okay? This is straight out of California Code of Civil Procedure. The general rule in appraising the sufficiency of a complaint for failure to state a claim is that a complaint should not be dismissed, because these guys had said, hey, they failed to state a claim upon which relief can be granted. And so they want it dismissed because, hey, you didn't make a proper claim. But this is what the court has said. It says the general rule is that it should not be dismissed unless it appears beyond doubt that the plaintiff can prove no set of facts in support of his claim which would entitle him to relief. And there's the case cites. And that demand for judgment. Every final judgment shall grant the relief to which the party in whose favor it is rendered is entitled, even if the party has not demanded such relief in his pleadings. That's U.S. versus White County Bridge Commission. Okay? So we know the court's on our side, the Supreme Court. A complaint may not be dismissed on motion if it states some sort of claim, baseless though it may eventually prove to be, and inartistically as the complaint may be drawn. Therefore, under our rules, the plaintiff's allegations that he is suing in criminal libel should not be literally construed. The complaint is hard to understand, but this, with nothing more, should not bring about a dismissal of the complaint. Particularly is this true where a defendant is not represented by counsel. And in view of Rule 8F of the Rules of Civil Procedure, which requires that all pleadings shall be construed as to do substantial justice. Accordingly, the complaint will not be dismissed for insufficiency. So, they want you to have your day in court. You've got to remember that there's a process of presenting evidence, arguing the case, that you should go through. If you come to a judgment before you come to a judgment, then you necessarily have been denied the full consideration of your case. They don't like that. Not on the Supreme Court level. Of course, every day they try to dump cases based on this failure to state a claim upon which relief can be granted. But that's a very, very casual basis for dumping complaints. They shouldn't do that. And the Supreme Court has said so. Paragraph 5 is basically the same thing. A complaint will not be dismissed for failure to state a claim even though inartistically drawn and lacking in allegations of essential facts. It cannot be said that under no circumstance will the party be able to recover. Why can it not be said that under no circumstances the party will be able to recover? One simple reason. You haven't considered the whole case. If you prematurely dump out the case, you haven't considered the whole case. If you haven't considered the whole case, how do you know it's going to fail? It's one of those little logical things, okay? Okay. And then we quote from Federal Rules of Civil Procedure, Rule 8F. All pleadings shall be so construed as to do substantial justice. And that was backed up by DioGuardi versus Durning. Okay. And then we have more of same. Okay? Really repetitious, but we put in a lot of case law supporting the fact that you don't just dump out a case. Okay. Now we get into the argument. Oh, here's a good one. When a wrong has been committed or a breach of duty has occurred, the cause of action has accrued, although the claimant may be ignorant of it. So even if you didn't know you had a cause of action, if the facts are there in the law, if the court knows about those things, it can give you it can award the judgment to you, even though you didn't know you should have claimed it.
Cards read for themselves.
Say again?
In a poker game, the cards read for themselves.
Yeah, in a poker game, the cards read for themselves. Okay, so now we argue the case. Counter-defendant's only demur is a special demur simply stating the cause of action fails to state facts sufficient to constitute a cause of action against the moving defendants. They do not show in what respect it fails to state facts sufficient to constitute a cause of action against moving defendants. On that ground alone, counter-defendant's demur should be denied. The demur fails to take into account that they acted as individuals without acquiring any lawful jurisdiction. The mere wearing of a robe does not confer upon them jurisdiction over their victims. Further, their pseudo-court did not act as, nor was it properly constituted as a court of record, nor was it a lawful nisi prius court, all of which they admit. Their actions were ultra-virus. Ultra-virus means that a jurisdiction has been defined and they exceeded that jurisdiction. Yeah, and that's a term that's normally applied to corporations. But you can use it here too, yes.
When this case was heard and they demurred, was there a hearing, but Aurora wasn't there? Isn't that correct?
That's correct.
And so when they proceeded with that, did they just kind of have a one-sided conversation?
Absolutely.
So there was nobody there that was actually reading anything into her record other than her paperwork had to stand on its own?
Exactly.
Okay.
Which it can do. I mean, that's legit. So, let's see.
Would they not have interpreted that as her not showing up, therefore she defaulted on her own case? They wouldn't interpret it as that?
Let me read
Going by
from
the statutes? Okay.
Let me read from the transcript. By the way, the transcript was one page. Okay, the court says, okay, Kecho versus people of the state of California. Mr. Lake, that's the defendant's attorney, right, for the judges. Good morning, Your Honor. Ken Lake for the defendants, moving defendants. Judge says, okay, we have a demurrer to the complaint. Apparently the plaintiff is in pro per, has not appeared today, and additionally, I believe my recollection is he failed to file a government claim on this. Sustained with leave to amend, or without leave to amend. Not even going to let her fix the problem, if there is a problem. Mr. Lake says, the action is dismissed as to these defendants? Judge says, yes, so you'll have to do an order for the court signature. Thank you, Your Honor. Sure, says the judge. Clerk says, will you give notice also to the plaintiff? Attorney says, yes. That's it. Oh, the clerk said, thank you.
I'll talk to you about it later on the golf course.
Yeah, probably, yeah. So you see, yeah, they just slam dunk, right? Well, it turned out that the judge was not in charge. Okay? That resulted in a writ of error. I mean, eventually they filed it, and so. But anyhow, reading from the answer to their demur, it is for counter-defendants admitted entrepreneurial actions resulting in plaintiff's injuries for which they are sued. See, they're entrepreneurs. They're on their own when they acted without jurisdiction. Okay? If they have lawful jurisdiction, except where constitutionally protected rights are concerned, they are entitled to the benefits of the umbra means shadow, of sovereign immunity. But where they factually have no jurisdiction, there is no immunity, and they must answer for their breach of duty to the plaintiff. It should be noted here that counter-defendant. Now, this transcript I just read. That applies to this. They're talking about this, what I'm reading to you now. It should be noted here that counter-defendants mischaracterize counter-plaintiff's action. Counter-plaintiff's action primarily concerns the counter-defendant's total lack of jurisdiction and their pseudo-courts to proceed. Counter-defendants acknowledge counter-plaintiff's objection to their jurisdiction and their failure to satisfy the burden of proof of jurisdiction. No amount of citing of codes, titles of nobility, and other accoutrements of office can relieve them of their obligation and burden to prove their jurisdiction when challenged.
Ouch.
Yeah. Judicial immunity is rightfully acquired once jurisdiction is lawfully established. But when there is 100% lack of lawful jurisdiction, judicial immunity as a matter of law simply does not exist for persons so acting. Counter-defendants are loose cannons. Their courts are not of competent authority because none is a court of record, as required by the 1879 California Constitution. They failed on 2 points. Okay, so here we are. Their courts are not of competent authority because none is a court of record. And then we list what a court of record is. Okay? And in here, we put the 4 basic requirements of a court of record. It's a judicial tribunal having attributes and exercising functions independently of the person of the magistrate. Okay? Proceeding according to the common law. Were they proceeding according to the common law? No. They were doing penal code statutes. Right. Its acts and judicial proceedings are enrolled or recorded for perpetual memory and testimony. That's called the record. Okay? That's what they're talking about. And I've already explained to you the only 2 things that make up a record.
Filing a decision?
Yeah, or the request for a decision and what the decision was. Okay, has the power to fine or imprison for contempt. And we didn't mention anything about the seal here. Or maybe that shows on the next page. But anyhow, they failed on 2 points. Not a proceeding according to the common law, and the tribunal is not independent of the magistrate who is conducting the proceedings. In this case, the magistrates each acted as tribunal. Yeah. California Penal Code, Section 808, says persons designated as magistrates, and it names all the different judges as magistrates. Okay. Further, as counter-defendants admit, Aurora Bautista Quicho timely objected to the jurisdiction of the court not of record, and she objected to their pseudo-nisi prius court. They admitted all that. Well, where do they go from here? Well, they have to break the rules. That's the only way they can go. And they're just determined to have their way. So this case has been hanging around on the trial court level as we built up these little pieces of evidence on each. Remember, we got a whole list of defendants here, so it took a lot of time. It would have been nice just to write one report on all of them, but we had to write quite a few reports, so it's taken us a lot of time. Okay. Let's see. Do we have any other points coming up here? I guess not.
Did you do anything to that judge that made that decision? Other than to void their judgment? Do they have to respond back to that?
No, the first time around, we never do anything to the judge. Okay. We assume he didn't know. You know, if somebody's stepping on your toe,
right,
the first step is to notify him that, you know, you don't hit him right away. You say, could you get off my toe, please? You know, yeah, you give him a chance to correct his error because it may be an error. Maybe it's just an accidentally stepping on your toe. So the second time that he steps on your toe, you know he knew better. Right. So that's when you punish him. See, you never, really, in my sphere of influence, I never sue somebody for a genuine accident. Okay. You know, the intent's important. You know, you see in the movies all the time, what was his motive? You know, that's what it's about. What's his intent? Right. Okay, if he intended to do harm, yeah, go get him. But if it's an accident, we can't prosecute somebody for a crime if he had no intent. So they have to prove the motive on the crime. And so that's here. We issue the orders vacating their orders. We put enough education in so that they know better. But if they do it a second time, then it's contempt. And that's exactly what we did. When we found them in contempt of court the next time, It was because they were doing what they should not be doing.
So you allow ignorance of the law as the excuse?
Absolutely.
Okay.
Sure. You have to. You know? But remember, it isn't really the ignorance of the law. It's the intent to do harm that we're talking about. You know, you can be as ignorant as you want about the law, you know, but when you intentionally know you're going to hurt somebody, I mean, do you have to have the law in writing? Yeah. Yes.
Can I ask you a question?
Oh, boy.
Let's say
Two of 'em.
if another state's court is injuring a family member and willfully, intentionally doing it, okay, would it be okay to bring him into, let's say, California's court to sue him here?
No.
Or would it have to do it
No, it's not okay. And the reason is because it's the diversity of citizenship, or not diversity of citizenship. It's the 11th Amendment prohibits the suing in the federal courts of a state by a citizen of another state. Okay? This was the result of the Civil War. There were all kinds of people angry at other states that invaded their state. So Congress put a stop to that by...
So in other words, you'd have to go to their state to sue them in their own state?
No, you can't even do that if you're from out of state. Now, if you're a citizen of your own state or people from your own state, sure, you can sue. It's just that you cannot be from another state. Okay? Now, it doesn't mean you can't sue. I mean, there's for example, I mean, you have the people that were there that were injured, your relatives, they can sue.
Right, but as far as, let's say, you know, it's a blatant case of torture. Okay, where do you find the remedy? Is it federal court, or do you have to find
Well,
it in their court?
whatever it is, they have to handle their own case. Okay,
What if
or
they're not in
hire an
capacity?
attorney.
Well, if they're not in a capacity to.
Well, the law does not protect he who slumbers on his rights. That's an old maxim. So, and being stupid is part of slumbering on your rights. I mean, really, if you don't have the capacity, you know, I feel sorry for you, but if you don't have the capacity...
Where he's at, it's very difficult for him to
Oh, yeah.
launch a
Well,
suit.
yeah. I mean, that's the breaks of the game. You know, we have no prediction on if we're born without the capacity. You know, you can blame God for it, I guess, but the thing is that we're talking about a legal system that is pretty much developed out of jungle law, survival of the fittest. And if you're not fit, you're not going to survive. So this is a game of intelligence, word manipulation, a lot of factors that have nothing to do, and in fact may be contrary to fair play. So as long as you're in control, maybe you can make sure your court runs fairly, but that doesn't mean someone else's court is going to run fairly. And frankly, you remember I said in order to run a successful case, you have to meet 3 criteria. You've got to be lawfully right, legally right, and morally right. And you're not legally right if you're a citizen of a different state stepping in on someone else's business. This whole concept is you're sovereign, you handle your own affairs.
Well, yeah, but don't you have an obligation when you see that they're committing crime against somebody to get the courts to enforce the law against them?
Well, yeah, you can report it. You just can't sue it. Okay? You can't sue. You can report it. You can notify appropriate authorities if you can find one that'll take the report and take it honestly. But yeah, you can inform. Nothing to stop you from informing. But that does not. You see, there's a difference between actually suing. And remember, you're not suing for yourself. You're suing for their behalf. Okay? Now, there is some hope here in that you should understand that a habeas corpus is not a lawsuit. Okay? Habeas corpus is a family fight between courts to determine which court has jurisdiction. That's all habeas corpus is. And you can run a habeas corpus in behalf of someone else. Okay? So you can do that. But that's the only exception. And one of the reasons there's an exception is because there's no damages involved. See? It's not. This is not a case of injury and suing for compensation for your losses. There's no compensation here. All you're doing is determining jurisdiction.
Okay, so in other words, you have to pop him free before he can, get him to sue. He has to be pop free before he can sue on his own behalf, because he has no access.
Yeah,
to
basically,
resources.
yeah, but he's on his own. I mean, they've made that very clear that you handle your own cases. You're not an attorney. Okay, you have a right to counsel, but right to counsel is not the same thing as right to representation. At least that's how I read it. And, well, okay, make up your own rules. See if you can convince a jury. If you can, then you got it. No, I mean, it's very harsh. The common law is known for being very harsh. I remember reading somewhere that that first-time burglar gets 30 days, minor burglary in the statutory courts. Any kind of burglar gets a death sentence under the common law. So, yeah.
In Aurora's case,
Mm-hmm.
in other words, she obviously has help from the outside. Would you?
They've noticed that, yes.
Well, I bet so.
And they've even said that they wanted to find out who it was because they wanted to prosecute for practicing law without a license.
Well, in her case, and with the help she's getting, would you explain how that comes about?
Well, in her case, she's taking full responsibility for everything. There's a team of us that are working in her behalf. We put together stuff. We run it by her. She takes full responsibility for approving it. She studies it. This gal is on top of things. She's no schlock. She looks at it, she reads it, she understands it. If there's some contradiction or some weakness in it, she'll point it out and say fix it. So I mean, basically, we're typists, and she's the brains of the outfit. And admittedly, she gets a lot of suggestions from sources, but ultimately she takes the responsibility for understanding it and okaying it.
And that doesn't leave them any recourse against those who are helping her.
Of course not. You have a right to counsel.
Right.
The king sits on the throne surrounded by counselors. He talks to them. He gets all sorts of suggestions from them. But who makes the decision? King doesn't delegate the decision. He makes it himself. He's responsible for his kingdom. So it's that simple, actually. It's interesting. I was looking over the Tennessee law on unauthorized practice of law. They call it UPL for short. And right there it specifically says that no one may basically write papers and do that sort of thing in a representative capacity. That's a key word, representative capacity. And I know that I've done a lot of work in Tennessee for others, but before I even started, I let them know, I'm not your attorney. You've got to look at this. You've got to understand it. I'll share with you my understandings, but you're the one who got the responsibility. You're the one who goes to jail if it fails. Not me. So I'm not representing you. I'm not even responsible. I'm not going to jail. You are. So, they get a very clear message from me that they best get involved with their case because I'm not going to help them if they're not involved. And they have to be really involved. I mean, where they're knowledgeable, they clearly see what we're up to. Maybe they didn't have the knowledge to put it together, but once it's put together, once they've had a chance to evaluate it, and they can decide whether or not this makes sense. And if it doesn't make sense, it's their responsibility to make it make sense. Yes. Okay. So, okay. Mm-hmm.
After in one of the courts where Ethel was attacked and brutalized, I've made it a practice when I go into the Torrance Island that I go to the sheriff's department first and let them know that I'm going to be at the Kecho case. Is it going to be possible that I need to come in under a white flag? These people tend to terrorize Aurora because she has friends. So, for those of you that could bring yourselves next Friday to be in her court, you know, it would be interesting to walk into the sheriff's department at 8:30 and say, you know, I'm going up to the Kecho hearing. Is that going to be safe?
Sure.
Because I always let them know, you know, if all kinds of hell breaks loose, they started it. I'm just an observer trying to be a witness. Because these crazy bastards will attack a process server. Whew. Well, anyway, before this is all over, I just wished I had the amount of money that they've spent to keep her incarcerated, because then the people of this state could afford a full investigation, and boy, we'd have these bastards strung up by their testicles. Anyway.
When is the hearing?
Pardon?
When is the hearing? When Friday?
It's next Friday. Right at Torrance Courthouse,
Hold it.
4th Street, Department G.
We won't have people on the table.
Want me to put that out?
Yeah, it's on September 9th.
Yeah, September the 9th in the island, and the reason we call it an island is because it's not a part of the United States of America or California. It's unto itself. But it'll be on the 4th floor in a judge's chambers who's been sued and lost, should recuse himself. But like we've pointed out so many other times, they don't like anything, even their own rules. So I would just simply suggest when you go in, stop in at the sheriff's office right when you walk in the front door there and tell them I'm going to be at the Kecho hearing on the 4th floor, and will I need police protection? Do I need to go in under a white flag? I mean, here's a judge who should be recusing himself. He's lost his lawsuit. He's admitted he's a kidnapping bastard. Yeah.
Well, we never use that word in the
Ron,
lawsuit.
did you have the address of the?
And the address is 825 Maple Street. And it's not the most difficult place in the world to find, but believe me, if we're going to have our country back, hopefully we won't have to go to the streets. Well, you better ask for protection. You're in definite need of it. But we're not going to go to that insane bastard Taylor either. This is Arnold. Arnold, by the way, is the guy that identified Aurora as a witch. Now, if you ever get to the History Channel and watch a program on punishment, you will see that when somebody is identified as a witch, there's never been a winner but the church.
What's the division?
Pardon?
What division?
Oh, I think it's G. Yeah.
Okay, well.
4th floor.
Okay, well, okay, we have further arguments here. Further, where the cause of action is not within the jurisdiction granted by law to the tribunal, it will dismiss the suit at any time when the fact is brought to its notice. So we brought it to its notice, and they refused to dismiss their case. Counter-defendants, when they had the opportunity, did not do so, nor did they consider the objection, but assumed the jurisdiction without proof of or ruling. Counter-defendants, let's see, what did I do? I think I just messed up. What paragraph was I on? Okay. Counter-defendants, as a matter of law, are not exempt from liability for their actions when they act with no jurisdiction. Counter-defendants, as a matter of law, are subject to suit when they act under color of law as if they were performing a judicial function and cause injury to the counter-plaintiff. The above entitled action is against individuals acting in their individual capacities under color of law. The government is not a defendant, nor has it yet appeared as a defendant in this action. Paragraph 12 of the action duly identifies complainer Doe. Remember the word duly? It means it satisfies both the requirements of statutory law and common law. Paragraph 12 of the action duly identifies complainer Doe as one with an alias of people of the state of California. Nowhere in the suit is the government itself named as a defendant. As an aside, it is highly questionable that public funds should be used to provide free attorney representation by Attorney General Bill Lockyer and his deputies for counter-defendants who acted ultra-virus and on their own volition. Yeah, you know, they provided, the Attorney General provided the defense for these guys. Imagine that. And you know, one of the things they were saying in their demurrer is that we didn't go to the Court of Claims first. See, normally when you have a beef against the government, you take it to the Court of Claims. The idea is this, or do I have to explain it? Does everybody know what a Court of Claims is about? Okay. All right. Well, you see, the sovereign decrees the law. So the sovereign state of California, and the state of California is sovereign within its sphere of control. It can't go outside the sphere. But as long as it stays within the sphere of control as defined by the Constitution, then it is sovereign. Well, when the sovereign does something like what we loosely say it breaks the law, okay, it didn't really break the law. What it did was change the law temporarily. Okay? No sovereign can ever break the law if he's the source of the law. He simply changed it. Okay? So there was recognized in the English system of law that although the sovereign cannot break the law and therefore cannot be sued for breaking the law, he does have some sort of moral obligation. So they set up the Court of Claims. Now remember that the sovereign king is always subject to his own court. His own court is the only court that has jurisdiction over him at all times. Other courts only have jurisdiction if he injures someone. But his own court has jurisdiction over him all the time. Of course, he can't injure, well, he can injure somebody, but he's not held responsible under the legal system. So you go to the Court of Claims, which is the court that has jurisdiction over the king at all times, and they make a moral evaluation, and if they agree, then they will direct the king to deliver the compensation to you. So it's not quite the same as a lawsuit. Well, as things work out, you make a claim, it doesn't get paid. It's just a 60-day delay for them. That's all. So it's a concept that does not work in modern government. Still, it's there. Now, they're saying in their objection, in their demurrer, that we never put a claim in. Oh, by the way, if you put in a claim and the claim is denied, then you can sue them. Okay, so there are limits to the sovereignty, and you can sue, but they do demand that you go to the Court of Claims first. Or on the municipal level, if you're talking about a city, they don't call it Court of Claims. They call it risk management. Okay? So you go to but it's the same deal. You present your claim to risk management. They evaluate and decide whether or not to pay. If you got a slam dunk against them, maybe they'll pay, but it's only a maybe. Okay? So that's the idea behind the Court of Claims. Well, now, when they start the trouble, when they bring an action against you and you do a counterclaim, you do not have to go to a Court of Claims. I mean, the action is already hot. They're in it. They're a party to the action. They're eligible to be sued. Now, they'll still argue that you didn't go, they want that 60 days while they hang you, okay? They want to delay you while they proceed full speed on their own case. Well, that's understandable. But the answer to that is sue them, okay? They've already admitted to being a party. Also, as a strategy, we sued the individual people. We claimed that complainer Doe had an alias, namely the people of the state of California. So the beauty of this technique is that when you sue them, you sue the individuals, and the individuals want the protection of the state. They want their immunity because it's actually state immunity, not their immunity. And they want the state to step in and protect them. Well, when the state steps in and volunteers to be a defendant, they lose their immunity. You can now sue them. Now, in Aurora's case, the state has not yet done that. The defendants have claimed that they were just doing their jobs. They claimed the sovereign immunity of the state, but the state itself never came in and said, "I'm the state, and I'll take the legal bullets." They never said that. So we've never heard from the state. We have only heard from the defendants as individuals. So it creates kind of a interesting legal little situation here. Okay. Yeah, see, nowhere in the suit is the government itself named as a defendant. Okay. Yeah.
What about if they say that is a policy? Wouldn't that... If they say it's policy... And
Is it on?
What if they claim that they're just following policy as being an employee? Would that throw the state or pull the state into it?
No, that's just their personal claim. We haven't heard from the state. We don't know if it is or not till we hear from the state.
Oh, so they'd almost have to use it as a defense.
They'd have to
They're
use
following policy.
they have to go beyond defense. They got to actually get the state involved as a defendant.
I see. Okay.
I would suggest that they should do. The state itself should jump in and say, "I'm the real defendant. These guys are under my protection. They were doing what I told them," which I'd say, "Thank you very much."
How would a fiction do that?
Well, that's a good question. How would a fiction do that, he says. Well, the way, as a sovereign of the court, you make up the rules. If you want to make a rule that you recognize fiction, you can do that. Okay? Or you might say, okay, if the state is, in fact, the perpetrator here, then let's hear from the state. But who's the state? Yeah, who's going to step forward and say, "I'm Mr. State of California"? Huh? Bill Lockyer. Well, no, he's not. He's an attorney. He gets a salary. The Secretary of State, he gets a salary. He's paid. So he's not the state of California either.
Bill? Bill?
Wait.
How
No, he's
would
not
you-
people either. Yeah?
How would you determine any vicarious liability?
Is it on?
Part of the
It doesn't
state?
sound like it's on.
Yeah, it is.
Okay. Yep, it's on.
Um,
You got to talk into the top instead of the side.
oh, sorry. What would constitute vicarious liability on the part of the state?
Well, their participation, their actual participation. It isn't just making the laws. If they make the rules, they're not part of it. See, they're just advisory. This is a republic, by the way, as opposed to a democracy. And in a republic, the rules are all advisory. You see, if they were mandatory on you, the sovereign, then you wouldn't be sovereign. That's why they have to be advisory. Now, in America, we have put a dividing line, you might call it. If you can manage to get 12 people all against you, then suddenly the advisory rule becomes a mandatory rule. Okay? I mean, that's our method. See, that's our method for determining where to draw the line. in Greece, a jury was composed of 1,000 people. The theory being that nobody was rich enough to bribe all 1,000. So in the United States, in England, actually, the English common law system, we've decided that the dividing point, instead of 1,000, is only 12. And I have to admit, it's pretty hard to get 12 people to agree on something, you know. But if you really have 12 people against you, actually it's more than 12. It's actually 25 total. You know, you have a grand jury. If 13 of the 25 vote against you, and then in addition to the 13, you got another 12 from the petite jury that vote against you, then you're in trouble. That's all there is to it. Because the law is not written. They can say anything is unlawful and put you in jail for it. I've given you all my pink shoe example, right? You know how, those who have heard my seminars before know how offended I am by pink shoes in my presence. Of course, I suspect, did anybody wear pink shoes just to challenge me? But you see, I'm really opposed to, I don't like pink shoes. I'm offended by it. And in my code system, I have, it's a death penalty, basically. You'll be executed for wearing pink shoes in my presence. The only thing that really slows me down is the fact that you can call on a jury. And I do have some doubts as to whether or not I can get 12 jurors to agree with my law. Okay?
Nick, I have a pair of pink shoes in my closet, and next time I'm going to wear them and see.
I was afraid of that. We may yet have a battle brewing here. You're going to call my obvious bluff. I'll show you. We'll see if it's obvious you bring in those pink shoes. Any guy who'd wear pink shoes has got a problem anyway. But anyhow, yeah.
Can you expound on the statement that in the Republic all rules are advisory?
Sure. Let's go back to the website with which you are so familiar now. And we go to the law notes. And we go to, let's see. We'll go to the foundation. And we talk about republic versus democracy. And then we go down here. And here's the definition of a democracy. The sovereignty is in the whole body of the free citizens. The sovereignty is not divided to smaller units such as individual citizens. To solve a problem, only the whole body politic is authorized to act. Okay? Let's go down a little farther. Oh, right at the top. Democracy, that form of government in which the sovereign power resides in and is exercised by the whole body of citizens, of free citizens, directly or indirectly through a system of representation. Okay? So you got to understand that the individual members of a democracy can argue all they want, but then they vote on it. When the whole body votes, that's the sovereignty that's speaking. There is no sovereignty on the individuals. So that whole body makes its direction. Everybody now has to obey. So in a democracy, there are no minority rights. Okay? In a democracy, the order comes from the sovereign people, and everybody must obey. No exceptions. Okay? Now, you look at a republic. In a republic, it's one in which the powers of sovereignty are vested in the people and are exercised by the people, either directly or through representatives chosen by the people, to whom those powers are specially delegated. Now, the concept of sovereignty is that the sovereign, if you are sovereign, is not accountable to a higher power. So if a group of people can come along and enforce something, well then, if it's disobeyed, well, enforcement then follows, right? So the sovereign is accountable to a higher authority, therefore he really isn't sovereign. So if you're going to have the individual be sovereign, you cannot make him accountable to higher authority. Well, if he's not accountable to higher authority, then whatever that other authority says can only be advisory. If it becomes mandatory, then you don't have a sovereign. So that's the nature of a republic. Now, in a republic, the sovereign can either delegate, just like a democracy. There's really no difference between a republic and a democracy. All the same things are done, but the sovereign individual, he only gets advice from the majority, whereas in a democracy, he gets orders from the majority. Yes. You got the microphone, yeah.
Well, I was just going to ask, do you have that definition from the 1920, I think 28 or 27 Army Manual of Democracy versus Republic?
No, I picked this out of the dictionary.
That was actually commissioned by the U.S. government, and they did an excellent job of defining the difference between democracy and republic.
Did it agree with these that you see here?
It was a little more forceful.
Okay.
It defined democracy as mob
In
rule.
fact, it was a lot more forceful, talking
Sure.
about how a democracy is basically mob rule and republic is, you know,
Has law.
but it
Common law.
But it gave a, you know, a whole you have it,
Yeah, but yeah, take a look at
but
this.
it's very good.
Uh-huh.
It's much different.
Well, let's back down here a little bit. Let's see. We go to,
Is it more argument?
yeah, I got something to add to this. Okay, let's see. Here we go. Law notes and, yeah. Foundation. Republic versus democracy, and the Army had its own description. Is that the one you're talking about?
Yeah, so,
Yeah, more detail, but basically, right. The authority derived through mass meeting or any other form of direct expression results in mobocracy. Attitude toward property is communistic, negating property rights. Attitude toward laws that the will of the majority shall regulate, whether it be based upon deliberation or governed by passion, prejudice, or impulse, without restraint, and so on. Okay, results in demagogism, license, agitation, discontent, and anarchy. In a republic, authority is derived through the election by the people of public officials best fitted to represent them. Well, you can do that in a democracy too. But the attitude toward law is the administration of justice in accordance with fixed principles established. Well, that also applies to democracy. A great number of...
If you get a majority of people, they can get together and take the minority of rights.
You don't have the mic on.
The main difference.
Go ahead and turn the mic on and say it
The
again. Let him say it again.
Okay. In a democracy, the majority of the people can get together and take and vote away the minorities' rights.
That's
Where
right.
in a republic, the rights are there. It's up to no matter 99.9% of the people can't take the rights of one individual away because his rights are over the government.
Sure.
So in a democracy, the people can just all get together and just decide whatever rules they want to go by.
Right.
You know, so that's the problem I have with democracy. I don't like democracy. It's
Well, I pulled the definitions directly out of the dictionary, and they're very concise.
yeah,
And-
they change as they do the law definitions. They change them every 20 years. They change the definitions of the words so that the people get more and more confused. If you
Well-
you know,
Well, that's exactly why. Well, that is. Let's put it this way. I pulled it out of the 5th edition, the older edition, and it seemed to say what I wanted to say, wanted it to say. So, and you'll see similar definition in the older dictionaries. They were consistent on that part. But you know, it really boils down to one's mandatory, the other's advisory. And when you make up a rule and nobody obeys it because they're not taking your advice, that pretty well trashes the rule. That's why a republic leads to freedom, whereas a democracy leads to a dictatorship. Okay?
I don't believe a republic can exist without the responsibility of each individual, because you have to have respect for your neighbor. You cannot trample on your neighbor's rights. And this requires responsibility, which they have eroded through the last 50 to 100 years from the general public. Just an example is having to have a seatbelt on when you drive your car. We should be responsible and not have to have rules to govern us.
Well, that's all true, but you know, I really think that the essence has been caught right here, because anything you do in a republic, you can do in a democracy, and vice versa. Excuse me. Wow.
Is that really true? If the majority says you have to wear a seatbelt, you have to wear a seatbelt.
That's in a democracy.
In a democracy, but that isn't true. Wouldn't be true in a republic.
No, it wouldn't be true in a republic. In a republic, it's advisory.
A republic is advisory?
Yes.
It's a recommendation, suggestion.
I thought we made our own law. It may be a suggestion, but it isn't a requirement.
That's what
it?
advisory means. It's a suggestion.
That's what I'm saying. It takes responsibility on the part of each individual.
Well, you have responsibility on the part of each individual, but that's not the same thing as free will. See, in a republic, you get information from the outside. This information comes to you, and you accept or reject as you wish, because you're in your sovereign capacity. If you're in a democracy, you cannot reject it. You must accept it. That's the only difference. I mean, everything else, they have voting, they have representatives, you know, it's all in where the sovereignty lies. The sovereignty lies in the group for a democracy, for a republic, and of course it takes responsibility. It takes responsibility for a democracy too. But any time somebody can walk in on you and say, you must do what I tell you, where's your recourse? You know, you'd have no recourse. In a republic, somebody walks in and says you have to do something, you tell them shove off. I choose not to. Well,
that's
This may be too philosophical, maybe for this discussion, but to me, a democracy erodes
that's right, because
responsibility.
That's right.
And a republic will not work without people that have a certain amount of responsibility.
Well, that's right. If you are not under control, ergo,
right,
you have to be responsible for your actions. And if you harm someone else, we'll beat you up.
And this is one of the things that bothers me about this country now in the last years since I was born, is I see an erosion of government playing God, and we have to look to them and not take the responsibility ourselves. We have to be responsible.
That's because it's being run as a democracy.
Right. Then that's my point. Is
that's the 14th Amendment.
It boils down to a thing where you, as an individual, have to take responsibility.
Well, you're right. You're right.
I think it all boils down to...
Are you talking into the mic?
Yeah. Hello.
Yes.
What it all boils down to is voluntary slavery in this country, and that's why we should be able to live the way we want to live as sovereigns, because you have the 13th Amendment, and further back, all the way back to 1775, when they talked about voluntary slavery. You have that right. Like I tell people, you have all the right in the world to be a voluntary slave if you wish, but you do not have that right to force that upon me.
Right. That's called contracting, voluntary slavery.
You can contract all you like and be a voluntary slavery, but you do not have that right to push that on me. That's democracy, when they have that right to
force it on
me.
you.
Right.
Well, it sounds like we're all in agreement.
Right.
Yeah. Okay. Okay. Counter defendants maintain custody of the counter plaintiff. Said custody served as a major impediment to counter plaintiff's timely compliance with anything other than the demands of the counter defendants. Now they want the fruits of their poison tree. And by the way, the fruits of the poison tree, that's a technical term. Okay? You create a situation that's wrong. And then whatever produces that, you now turn around and you get the benefits of it. That's the fruits of the poison tree. If the tree is poison, you can't have the fruit that it produces, no matter how good it tastes. Okay? So we're saying these guys created the problem, and now they want the benefits, whatever they perceive them to be. So under color of law, they want counter-plaintiff's action denied because they claim that counter-plaintiff failed to plead timely compliance with the requirements of a government entity who is not a party to the action. In summary, counter-defendants set up an unconstitutional court not of record over the objection of the counter-plaintiff. They ignored the objections and failed to prove their jurisdiction. They now admit all that, and now they want the protection of this court of record. Their general demurrer should be denied. Okay? And we have note 9 here. What does it say? It says, demurrer may be to the whole or part of the pleading, but if to the whole and a part be good, the demurrer will be overruled. See, so if you have a demurrer to this whole pleading, which is what they did, if any part of it is found good, then it must continue. You can't just dismiss it. Counter-defendants wish to present other matters at the hearing. Counter-plaintiff objects to trial by surprise. They were served. They demurred to the action under full and fair conditions. They may not be permitted to present any new matters beyond the content of the action and the demurrer. Now, let me explain this. Whenever you file a suit, you do and say whatever you do and say. They come through with a demurrer. They're saying, hey, we want to get rid of this suit because of blah, blah, blah. And they had time to thoughtfully put through all their ideas. Then you turn around and you answer that. Answer their demurrer. Okay? Now, in their demurrer, they said specifically that they wanted to present other information at the hearing. No, 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 no. Doesn't work that way. Okay? You have to understand that in any motion, what you have to do is present the ideas fully. Okay? And the other side gets a chance to answer it fully. And then you get a chance, again, to comment on their answer. Now, in your original thing, you bring in all the new information. I mean, that's what makes it original. In the answer, they contradict it and they bring in their new information. Your reply is limited to only the information that's in those two papers. You cannot bring in something new. Because if you did bring in something new, then they would have a right to answer that. Okay? So it's limited in our modern procedures. We limit it to 3 papers. The original motion, the answer to the motion, the reply to the answer. Okay? So they're saying they want to present new information. We're saying, no, no, we're not going to put up with that. Okay? Because that's what attorneys like to do. See, the attorney's stock in trade is confusion. If they can stir up the pot, get confusion, now that leaves it open for the judge to decide whatever direction he wants to go, wherever his biases lead him. So we don't tolerate that. You know, the trial, if you want to call it that, is actually in the papers that get filed. You don't have to have a hearing. Okay? The only reason for a hearing is to give the court an opportunity to ask questions to clear up any points that the court is confused about. Anytime you go to a hearing, I don't care what they say. If it's new, you object. You don't let them bring in new information. You don't let them bring it in whether it's under oath or not under oath. You just don't let them bring it in. You object. Now, of course, they're going to say it anyway, but the point is you get your objection in because that's your basis for dealing with it later. If you fail to object, it means you agree. So don't fail. Okay? And then we said, to conserve the resources of the court, counter-plaintiff invites the court to consider on its own motion to consolidate all the hearings of the demurrers of all the counter-defendants, or at least that the ruling on the demurrer be taken under advisement and delayed until all counter-defendants have had a full and fair opportunity to respond. Essentially, all the same points, facts, and points of law are being introduced. By consolidating all the hearings into one, the court may achieve a greater efficiency and consistency in time, resources, and rulings. Well, in fact, what happened was we handled them one by one. Okay? But it could have done that. We could have insisted on no rulings until we got them all in. Now we have the signature here, okay, to her answer. one of the things that we did was we had a seal on everything. Yeah, you had a... Well, you have the initial proposition, usually called a motion. Then you have the answer to the motion. Then you have the reply to the answer. So they're called motion, answer, reply. Do we need some air conditioning in here? Yeah. Maybe we can get them to turn it on briefly. Yeah, talking about the seal now. Now, let me show you what a seal looks like. In fact, I'll show you what Aurora's seal looks like. Yep. Yep, Corel photo paint, Corel draw. What's that?
Must be some artwork from you, huh?
Yeah, it is art. It is for artwork. Yeah.
Seal. Last one.
There it is. This is what a seal looks like. Okay? It says Aurora Bautista Quicho, her date of birth, June 5, 1950. It has the word seal because otherwise you don't know it's a seal. Okay? It has some key words, wisdom, beauty, and justice. And it says Dei Gratia. Now, Dei Gratia is a Latin phrase that's been used for, I guess, thousands of years, hundreds of years anyway. And it means by the grace of God. And basically the concept was the divine right of kings. By the grace of God, the king was where he was, occupied it. And so, if you're a sovereign, you're there because of the grace of God. So we put that on there. So that's your seal. We use that seal. You take it, you crimp the paper, okay, and now it's sealed. Now, sealing a paper is really very effective because, you see, in a normal contract, let's say, I promise to give you something and you promise to give me something in return, like buying a car. I give you money, you give me your car. Okay? That's a normal bilateral contract. A unilateral contract is not valid. If I promise to give you $1,000 next Sunday, you cannot hold me to that contract. It's a unilateral contract. There's nothing in return, so there's nothing to enforce. If I change my mind later, that's the way it goes. It doesn't matter if you planned on it or not. Okay? So unilateral contracts are out. I can even sign a piece of paper saying I'll give you $1,000 next Sunday. Not enforceable. Okay? But if I put my seal on it, it is enforceable because the seal itself is the consideration. Okay? So, seal is very important. You've heard signed, sealed, and delivered, right? That's the seal is important. They try to legislate the seals out. They try to say, well, signature is as good as a seal. It isn't. Okay? You'll notice that in the rules require that all 100% of the writs and orders of a court must be sealed. Okay? So seals are important. They want to put you in a position disadvantaged. By you not sealing your papers, you've left a hole in the authority of your papers. Okay? On the other hand, maybe you don't want to seal all your papers. Yes?
But if you offer to give $10,000 and then you give consideration,
That's all from one side. Can you hear me?
Yeah, now, when you talk close, we can.
But where is the consideration from the second party? From one party, we have an offer of $10,000 and consideration of a seal. From the other party, there's no consideration.
No, the seal is the consideration. When you know, think of the word consideration in another sense. You've considered, you've taken it seriously. You really meant what you said.
But I thought there had to be consideration from both. The seal is also from you giving the offer.
Yes, but the seal makes the difference. It's the king's promise.
It offers consideration to the other from the other side also.
Yeah, it means you really meant it. So you can be held to what you really meant. You didn't really mean it if you didn't seal it. See, just signing it's not enough. You got it. Once you put that seal on it, that carries the weight of consideration. Yes. We know you really meant it when you seal it. When the king issues an order, doesn't he seal it? You know, they had the wax seal. Well, he issued the order. It was from him to somebody. He didn't ask for anything back. He says, just do it. Okay? That's the words. Yep. You got to have the delivery, too. Got to get it to whoever it's intended for.
Okay. Going into a different territory, we've been talking about in the banking system, promissory notes where the person signs it, gives it to them, and there's usually no consideration from the bank. But they are sealing it, are they not? They're stamping it.
I don't know. I don't know. No, stamping it doesn't mean sealing it. Does the stamp have the word seal in it?
No, it doesn't.
Well, it's not a seal then. Has to have the word seal. That's a pretty common requirement. You look everywhere on all seals, somewhere the word seal appears. Corporate seals are that way. State seals are that way. The federal seal. It says the Great Seal of California. Okay, you got to have the word seal in there.
Does a red thumbprint over the word seal, is that as effective as that seal?
Well, I wouldn't say in practical terms it's as effective, but theoretically it is. Yes. As a matter of fact, you don't need the thumbprint. You just need the word seal. Okay. The United States District Court in Las Vegas has a little rubber stamp that when they issue a paper, they stamp it with this rubber stamp, and all the rubber stamp says is seal, S-E-A-L. That's their seal.
Do the words wisdom, beauty, justice have any significance, or is that her choice?
Just her choice. Actually, the person who made it up chose it for her. No, I don't know. Somebody I probably know. Okay, well, all right, let's see. We're back to this. Okay. Okay. So that is the action that was filed. When we file things, remember this, that the person who controls the seal, that's the one who can make the commitments. See, the Secretary of State, for example, can seal things, and those have the force of law behind them. Okay? The sovereign didn't do it. The Secretary of State did it for the sovereign. So a lot of papers that went in for Aurora were not signed by her. Okay? Her signature was reproduced, as you can see here, and then the seal was put on it because the seal is the real authority. Okay? And another thing is that under the Uniform Commercial Code, assuming you want to apply it here, as it relates to signatures, the Uniform Commercial Code says that, in essence, a signature is anything the creator of it says it is. So you could take a typewriter, type the letter XXX, and if the originator of that paper says that's my signature, then it will be. I did a report for the Ohio Supreme Court one time. They were considering having filing by fax. And so I researched the concept of signature. And in my report to the court, I said that if the originator of that fax copy that comes through says that is signature, then that copy is as good as the original under the Uniform Commercial Code. Now, I don't know how much effect I had, but I do know that it wasn't long after that they went to fax filing. But I had identified that as the critical issue. By the way, they didn't know me from Adam. Basically, I happened to be on somebody's mailing list. Some judge that was working for the court, for whatever reason, had me on his mailing list, and he sprayed out a request to all attorneys and such to help out in deciding this thing. So I produced this report, but I'm officially on the record as one of the contributors to the Supreme Court of Ohio. So, for what that's worth, I don't know. Nothing? Oh boy. Already I'm profiting.
On the signatures of Blacksforth says that a signature can either be a logo or any mark.
Anything.
And sometimes I think, and I'm not certain on this, but it would seem that when we get these unsigned, as we think of being unsigned letters, say from the FTB or something, they're really signed because
Yes.
they have the logo on the top.
All you have to do is ask them, is it signed? They say yes, okay.
Yeah, and there is nobody's name, wet signature, but the logo's there, and that is, according to Blacksforth, a signature.
Well, that's the seal, I guess, right? In a sense.
It doesn't say seal. I mean, Black's doesn't say it's a seal. It just says that anything that identifies
Right.
them is a signature.
Uh-huh.
And we always think of it as being the written, but that's the autograph.
Right. Yep. Anything is a seal. All you have to do is check with the originator. If he says that's his signature, then that's what it is.
Or if he says it isn't, then it isn't.
Who?
What if he says it isn't?
Then it isn't. If he says it isn't, then it is not. Yeah. That's correct.
Even though you autograph.
Well, I mean, they come into fraud, you know, or something. If there's a witness that says, yeah, I saw you sign it, and you're saying, no, it's not my signature, but they're saying, yeah, you know, the customary definition of a signature, well, then sure, it can stick. We can deal with reality. You know, what was your intent at the time you created it? If you change your mind later, that's a no-no.
If they gather your signature under threat, duress, or coercion, you can say that that's not my signature.
That's true.
Because it was derived out of threat, duress, and coercion.
That's right. Hopefully that got recorded. Basically, he said that if the signature is obtained under duress, then it's not a signature because it's just not legitimate. Okay, well, anyway.
Bill, that was threat, duress, and coercion, TDC.
Yeah, well, TDC is not recognized by UCC, whereas under duress is and without prejudice is, and under duress and without prejudice, those two phrases are synonymous. They mean exactly the same thing. I don't know where threat, duress, and coercion comes from, but it's been very popular. It's been running around the patriot community for years. But the fact of the matter is, you look at the UCC says that it says basically you can sign without prejudice or under duress or words to that effect. Well, I don't like to argue. So if you use under duress or you use without prejudice, it's very clear. If you use anything else, now you're going to have to argue whether or not what you used is words to that effect. Yeah, why not take the easy way and just use whatever it says? That's also, by the way, the thinking behind claiming that I'm one of the people. You know, that's exactly the wording that's used in the preamble to the Constitution. So I don't know what people are, but I sure know what the relationship is between people and government. People outrank the government. Whatever the people are, they outrank them. So, okay, well, anyway, that is the complaint that was put in. Or actually, it's called an action. You can get real technical if you want, but there's no need to. An action is different from a complaint. An action is basically at law, whereas a complaint is in equity. And it's kind of but if you call it a complaint, that's just fine. Just like I said, when I was dealing with that clerk, and that clerk only understood complaints and did not understand counterclaims, I said, fine, we just change it. or add to it, and that was just fine. It worked. So, okay. Let's go to, we have the law of the case, okay? Just a quick run through the law of the case. Remember that the law doesn't exist until some sovereign steps forward and decrees it. All right? So we quote Section 11120, which we have since been informed has been repealed. Basically, the people of this state do not yield their sovereignty to the agencies which serve them. Then we have 54950, which basically says the same thing. Okay? Laws, whether organic or ordinary, either written or unwritten. So see, it doesn't matter if it's written or unwritten. If it's a law, it's a law. And the common law is what's unwritten. Now, what does unwritten mean? Unwritten does not mean you can't find something in writing. When you say a law is unwritten, what you're really saying is that you cannot find the original authoritative source of that law. If you look at a statute, you can, on any statute or code, you have traceability right back to the legislature. You can even tell who voted on the law. Okay? So the laws can be written. But if they're unwritten, that means that we're talking about custom and usage. It's the way we do things. Since time immemorial, nobody knows where this rule came from. I mean, take for example, I'll just give you a simple rule that if you violate it, people will think less of you. Let's say you're walking down the street. Somebody comes the other way that is a friend of yours, and that person says hello. And you just look at him and keep walking. Well, what's that going to do for your friendship? Okay? So right there, you violated a common law, a law that's been around since time immemorial, meaning we don't know where it started. Where did this come from, this thing we say hello to each other when we meet? What does that do? It doesn't convey information, doesn't do anything. Okay? But we do it. And if you don't do it, you're in trouble. Okay? You just might lose a friendship. You know, somebody's going to say, well, what's wrong with this person? You know, you do that 3 times and you've lost a friend. Okay? First time, they might let you get away with it. Next time, they'll be asking you, were you feeling bad that day or something? It's a very important law. Very critical law, in fact. All of society would fall apart if everybody quit responding to a first hello. So that's the common law. Custom and usage is what we customarily do. It's the usages that we put things to. And if you do something different, you're really weird or something. I remember the reaction of some of my friends when I showed up at the beach fully dressed in an office suit. You know, tie and... It was a pretty suit. It was all green, you know, dark green, but it was a nice suit. I got a lot of reaction. My friends knew me, so I didn't lose any friends, but they thought I was really weird. In fact, one of my friends invited me out to go boating with him, and he told me specifically, you better not wear a suit. You better wear casual clothing. So I did. I had some tennis shoes, and I had some pants, and a shirt, all of which I had been wearing when I carried batteries with battery acid, sulfuric acid on them, and they were full of holes. And when I showed up, I looked like something that was really dragged out of the ghetto, you know. So, first thing they let me know is they didn't know me. And we went out on a boat, they made me sit at the other end. It was a 10-foot boat, but I had to sit at the other end so nobody would think I associated with them. But you know, I mean, it was in fun. We had fun with that. But the fact of the matter is, it shows you the strength of custom and usage. I mean, it's hard even to play a joke doing that. But what, you know, you run the danger of being really thought weird. Actually, I was weird, but that was another story, you know. So anyway, okay, laws, whether organic or ordinary, are either written or unwritten. A written law is that which is promulgated in writing, and of which a record is in existence. What's the record? We're talking about the legislative court. The legislature is a court, a special court, and it creates law for the state. Okay? The organic law is the constitution of government and is altogether written. So there is no unwritten constitution. Other written laws are denominated statutes. The written law of this state is therefore contained in its constitution and statutes and in the constitution and statutes of the United States. So you see that any of the laws of the United States are the laws of California according to this. Of course, they cannot conflict with the state constitution unless the federal constitution, the laws that are passed specifically put in an override to make sure. Okay. Any judicial record may be impeached by evidence of a want of jurisdiction in the court or judicial officer. Well, all that stuff that's going on in the Torrance court, we have evidence of lack of jurisdiction. I mean, in their demurs, they admitted no jurisdiction. So therefore, it's an impeachable record. So they're doing what they're doing, but in the long run, I think they've got a problem. If you can show collusion between the parties or fraud in the party offering the record, and right in the record, the docket sheet, they point out that they had the concurrence of the public defender. Well, what's the definition of collusion? Okay. At the Revolution, the sovereignty devolved on the people, and they're truly the sovereigns of the country, but they're sovereigns without subject. There's none to govern but themselves. The very meaning of sovereignty is that the decree of the sovereign makes law. So if you take this word sovereign seriously, then, hey, you can make up law. Make up any law you want. Your only limitation is you can't impose on the rights of another sovereign. Okay? And you also have to pass the jury test. If a jury is called in, they might decide your law is no good. However, judges are very, very reluctant to tell the juries that they can suspend the law. Yeah. Okay. The people of this state, as the successors of its former sovereign, are entitled to all the rights which formerly belonged to the king by his prerogative. So there we are. We're establishing how you determine the rights. Just ask the king. He'll tell you what the king's rights are. A consequence of this prerogative is the legal ubiquity of the king. Ubiquity means he's everywhere. His majesty in the eye of the law is always present in all his courts, though he cannot personally distribute justice. Okay? You cannot non-suit the king. You cannot say to the king that he doesn't have a suit. Okay? He may not be personally there, but you can't throw out his suit. Not if he's a king. The declarations of rights may not be construed to impair or deny others retained by the people. Yeah, just because you have a list doesn't mean that there aren't more. And although what you have here, that's a statement in the California Constitution. It's also in the federal Constitution. Okay? Any rights not specifically delegated or retained by the states or the people.
Is this on your website, or can we get a copy of this?
Well, all of this is in that contempt ruling. But I copied it over and put it in this too. Okay? The assertion of federal rights, when plainly and reasonably made, is not to be defeated under the name of local practice. Okay? They can't say, oh, we don't do things that way here. Okay? Okay. Is it time to turn off the air conditioning? Are we cool enough now? Okay. Who's the air conditioning person here? Yeah. All right. Okay, yes.
Isn't it true that equality under the law is paramount, that if a law protects a right in California, it also has to protect that right in Arizona?
Oh, that I don't know. I'm not aware of that. There is some discussion among gun control circles that if you have they want to pass a statute in Congress saying that if you have a concealed weapons permit, that it will be recognized by all states. But they have a real interesting problem that came up in the discussion of that. I don't think they've passed it yet, but they've been talking about it. And what makes it interesting is this. In the state of Alaska, if you are a resident of Alaska, you automatically are authorized to carry a concealed weapon. So now if an Alaskan goes to another state, shows his Alaskan driver's license, that is his permit to carry a weapon concealed. And they would have to recognize it purely because of his citizenship. And that is really upsetting a lot of the bureaucrats. Okay? Okay. There can be no sanction or penalty imposed upon one because of this exercise of constitutional rights. You can't be punished for exercising your right. But you all know that as soon as you assert your rights, the bail goes up, doesn't it? You know? That happens. Then we have the admission of California to the Union. They found that it was a Republican in its form of government, so they let us in. And what is it? We went through what a Republican government is. The state of California is an inseparable part of the United States of America, and the United States Constitution is the supreme law of the land. So right there you have, in the California Constitution, an admission that it is part of the federal government. That Constitution is a federal Constitution, the 1879 Constitution. The 1849 Constitution is a real Constitution. And I have been told by some people that up in Central California, there are some buildings there, government buildings, that are maintained. The lights are always on, and there's nobody in them. No furniture. Just the buildings are there. And they have speculated that that's the real California. They have to keep it alive. Okay? Yes?
Are you familiar with, was it Stockton was originally the capital of California?
No, I'm not familiar with that.
Monterey. Okay, because, huh?
Monterey, maybe.
Vallejo? Okay.
Monterey and then Vallejo.
Because a friend of mine had asked, he said, a friend of mine had asked about who is really the governor of the California state. And he says, well, he's somebody up in Stockton.
Well, it could very well be that they're running it secretly, you know. They have to, the structure has to be there, because if it doesn't, then you will automatically have centralized government in Washington with all the evils that come with centralized power. So they do have to have that constant threat of diluting the federal government if the federal government misbehaves too badly. Yes.
I've noticed in a number of courts that I've been in, the state courts, that there's one room that has a flag without fringe.
Yes.
And
right.
I believe that this is the same thing that you're talking about with Stockton, that they have a token room in each court in order to be in accord with the Constitution.
Sure. Well, it was an interesting...
A court of record.
Yeah. An interesting thing happened, which we need to check out here. But we put in this writ of mandate to the appellate court. And when it came back, their order came back denying it. It said the name of the court was Court of Record. I've never seen the government do that before.
I put that on there.
What? You put that on there?
Give her the mic. Give her the mic.
I don't think so. Not what I saw.
When I had to fill out the papers for what I was filing, I put, because I didn't know who was the one, I was having the feeling of an appellate court. And so I didn't know which court was being appealed. So I put Court of Record, and that's how I identified
But we
it.
weren't appealing.
I know, but I didn't know that at the time when
Yeah.
I was filling it out.
What-
I actually identified it as a court of record for Quicho versus the people.
All right, let me bring that up.
There was a form I had to fill out.
Oh, it was on a form, not our papers.
No, it was a form that I had to fill out when I had to present the case for them to do. And that was done on the Monday, and then they said, well, it was $660 to file this.
Sure.
And so anyway, that's basically what took place. I'm the one that wrote that in there, so they identified it.
Okay, because see,
But I brought it to their attention. That's why I wrote that.
yeah, but see, it was very clear here. The court, you see, the court that we're filing in is in the Court of Appeal of the State of California, Second Appellate Division or District, Division so-and-so, and you had to fill that in, what division it was.
Right,
Okay.
but he took it from me, and there was a paper that was just a little small paper that I had to fill out for what was the I guess it would be the short title.
Well, I'm surprised that he didn't simply tell you what to be there, because this is the name, the Court of Appeal of the State of California. That is the court that we're moving in, and this is a petition for a peremptory writ of mandate.
Right.
Okay, and it's verified, and it's regarding these other two courts here. So there's
Right.
nowhere.
I wrote that stuff in, but I basically put from a court of record.
Okay.
So I identified it as that, and he didn't.
Did you get a copy of it?
No,
Okay.
it was just a paper that I had to
I
fill
guess
in
someday
to-
I'll go
to
down
file.
there and look and see just exactly what that's all about. Because see, right here in this caption, all the information is there that they needed. You know.
Right.
I have no idea.
Well,
I
he
mean,
handed me a paper that I had to fill out
Sure.
for filing the case.
Okay. Well, it came back that the court of record was somehow, they titled it court of record. It didn't make sense to me. Well, okay. Such is life. Yes.
Maybe you need to refile it, because maybe they only filed her paper, not yours.
Repeat that again.
Can you hear me? Yeah. Maybe you might need to refile it, because maybe they only filed her paper that had just that one page and not filed that. Oh, no. Are you sure?
Well, the thing is that it really doesn't matter, because again, titles do not control. What controls is the body. Okay? It says here, the appellate court may issue a writ of mandate to an inferior tribunal, and so on. My interest in the writ is presently existing. A writ of mandate would be beneficial to me, real and actual, direct and tangible. A writ of mandate would result in my incarceration being terminated and my liberty being fully restored. And so we have a summary of the case. We're talking about it. Okay? And then we put in this background. And this describes what's going on in the background. We say the inferior court known as the Superior Court of the State of California, case number so-and-so, and so we get very specific. So, and we are going to the appellate court because we have the title right up here at the top. Okay? So, if we quote out of 240, Title 20, Title 18, 242, conspiracy against right, if two or more persons conspire to injure, oppress, threaten, okay, that's a crime. 18 U.S.C. 241. Deprivation of rights under color of law, that's what they were doing. The feds, they say, whoever under color of any law, statute, ordinance, regulation, or custom willfully subjects any person in any state. That includes the sovereigns are protected by the federal government too, because they said any person. Okay? So, property rights of citizens. All citizens of the United States shall have the same right in every state and territory as is enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, and convey real and personal property. So they made everybody the same. So, civil action for deprivation of rights, you can sue for it. So, see, all this is decreed. Okay? Conspiracy to interfere with civil rights. By the way, I happen to be reading the Florida Civil Rights Statute. And among the many things that they were trying to protect, they were trying to protect I can't remember the exact words, but in effect it said they wanted to protect the productivity of the citizens for the state. What does that tell you? Well, you see, they are subject. If you're a citizen, you're subject. So you have no rights. You only have the privileges granted. And your productivity is important to the state, and they have claim on it. That's the whole idea of the civil rights. Okay? Action for neglect to prevent. Every person who, having knowledge that any of the wrongs conspired to be done and mentioned in Section 1985 of this title are about to be committed, and having power to prevent or aid in preventing the commission of the same, neglects or refuses so to do, if such wrongful act be committed, shall be liable to the party injured. Okay? You cannot just stand there, watch a car coming down that's going to hurt somebody, and just watch it happen. You have an obligation to give them warning. Okay? You don't have any obligation to commit suicide to save the person, but you do have an obligation to warn if it's not going to be harmful to you. Okay? What is a court? We define what a court is. Person in suit of the sovereign, the place where the sovereign sojourns with his regal retinue, wherever that may be. It's out of Black's Law Dictionary. Now notice this. The court is the place where the sovereign sojourns with his regal retinue, wherever that may be. So when they pulled Aurora out of jail, brought her over to this criminal court, her court traveled with her. So when they violated her court order, they were committing a contempt right in view of her court. So we went direct back with a contempt finding. No trial needed. Okay? Kind of neat. You all know what a court of record is, so we won't go into that. Okay? Oh, here's the definition of a court. An agency of the sovereign created by it directly or indirectly under its authority, consisting of one or more officers established and maintained for the purpose of hearing and determining issues of law and fact regarding legal rights and alleged violations thereof, and of applying the sanctions of the law, authorized to exercise its powers in the course of law at times and places previously determined by lawful authority. If you're a sovereign, you decree the law, you can create your own court. Okay? The following persons are magistrates, the judges of the superior courts. And of course all the other judges too. We just did an excerpt on 808. Okay? Our justices, sheriffs, mayors, and other ministers, which under us have the laws of our land to guide, shall allow the said charters pleaded before them in judgment in all their points. That is, to wit, the great charter is the common law. See, under the Magna Carta, if you demand that you want the Magna Carta to be the common law, the officials must accept it. Now, if you don't demand it, they cannot force it on you. So it's totally your choice as to whether or not you want the Magna Carta to be the common law. But there are some interesting things in there, like, for example, no cop can be a witness. Uh-huh. Yeah, you want to see that one? I think I got some interest in that, right? Okay, well, here it is. We go to the foundation, and we go down to Magna Carta. Here we'll go to the interpretation. It's easier to find of Magna Carta.
You got it right there. Starts on line 30.
Down here.
Up there.
Right there.
No sheriff, nor bailiff of ours, nor anyone else shall take the horses or carts of any freeman for transport unless by the will of that freeman. No, that's not the witnessing. Okay? It says, no sheriff, constable, coroners, or other bailiffs of ours shall hold the pleas of the crown. That is the prohibition against suing in the name of the people. See? No member of government may make a complaint against any individual. To hold the pleas of our crown means to sue in the name of the king, or in America, to sue in the name of the sovereign people. So the people versus so-and-so doesn't fly. It won't work if you don't agree to it. So how do they get you to agree with it? Arraignment. It's the arraignment process where they get your agreement to go ahead and let them hold the pleas of the crown.
Do you understand the charters? Is that it?
Well, that's part of it. But no, how do you plead? Guilty, not guilty, no contest. And you say, wait a minute, I object to the whole damn system. You know? But let's see. But we still didn't find the one about witnesses. Okay. Here it is, right here, number 38. Okay? Number 38 says, no bailiff on his own simple assertion shall henceforth put anyone to his law without producing faithful witnesses and evidence. A faithful witness is somebody who's not on the king's payroll, not on anybody's payroll, okay? He has no biases. That's a faithful witness.
That's the interpretation.
That's the interpretation. Yeah, the dark is the interpretation. This up here is the original Magna Carta. Yeah. Okay. See, they had the same problems 700-800 years ago that they have today. Okay? Okay.
There you go.
Okay. So, all right. Henceforth, the writ which is called precipice shall not be served on anyone for any holding so as to cause a free man to lose his court. A precipice is an order to show cause, and it's issued against property, which is usually what the issues are about, you know. But, and by the way, your personal rights are considered property.
Really?
Yeah. So, they cannot issue it in such a way that it causes you to lose your court. Okay? If any claim, statement, fact, or portion in this action is held inapplicable or not valid, such decision does not affect the validity of the other portion of this action. Well, that's just normal boilerplate. The rest is boilerplate. Okay? So that was the law of this case. Okay? All right, so we did that. We then had, at some point, we issued an order to discharge. Okay. Bring that up. It's a PDF file. Takes a moment to come up. Okay, here's an example of numbering. Okay, you have a 1-inch margin all around. The numbering is on the inside of the 1-inch margin. So the left side of the text is where the 1 inch is. But that's how you number the pages. Go 1 down to 27 or 28. And then you have a page number like this, a horizontal line, and then a title to the paper. So it's somebody flipping through, because your papers are bound at the top in the court file. So a person can look at the bottom and see where it is in your papers. That's the idea. That's the proper format for California. We didn't necessarily do it right, but in this particular case, this is done right. That's exactly how it should look. Okay. So basically, this is the proof of service. So that's not what we want. What we want is the actual order to discharge. That looks like proof of service also. What happened? Proof of service, oh, they're both proof of service. Okay. Huh. What happened to that? I guess that's just the proof of service. Elsewhere we have the order to discharge. I think it's over here. Order to dismiss. Yeah, that's it. Order to discharge. Right. Okay, so here's the order to discharge. All charges in the interest of justice. Now remember, this is from her court to their court. And this is the basis for our big argument in the appellate court. Okay? which they've tried to dismiss. So we addressed it to all of them. And now you see these little slashes here? These slashes are the customary way to fill blank lines. If you got a lot of blank lines, for whatever reason you want to insert blank lines, that's how you do it. You put in 10 of these slashes on each line that you want to force blank. And basically what we were doing is we were forcing the order to start on the next page, okay, in order to make it easier to read instead of having it flow over the margin. Comes now the above entitled Court of Record, a Superior Court of General Jurisdiction of Aurora, Bautista, Quicho, on its own motion and orders as follows. Now that's another important idea. The court itself can make motions, okay? So the court makes a motion, and when it makes a motion, it then, everybody gets served with a copy. And then, of course, people can answer the motion if they wish. Okay, so it says that all barratry shall cease. Barratry, here's the definition. Webster's 1828 dictionary says it's the practice of exciting and encouraging lawsuits and quarrels. Bouvier's Law Dictionary describes it as a crime. In Old Law, French barratry, signifying robbery, deceit, fraud. In modern usage, it may be defined as the habitual moving, exciting, and maintaining suits and quarrels, either at law or otherwise. And the statutes specifically exempt attorneys from barratry if they are representing a client. So the client may be barratrous, but not the lawyer. Okay, well, anyhow, here comes now the above entitled Court of Record. Let's see if we can expand this up. Okay, text width. There we go. That's better. That all barratry shall cease, all vindictive proceedings shall cease. When you are in court defending against a charge, if you raise the issue of vindictiveness, the burden shifts to the government. The government must prove that it's not being vindictive. You do not have to prove it's vindictive. The presumption is it is, unless it proves otherwise. Of course, if the judge is sitting up there, that's good enough for him. Whatever they say, you know, that's proof to the court. But basically, when you bring a charge of vindictiveness, they must prove that they're not. Okay, they can't just say no, we're not being vindictive. They got to actually show that they're not. It's kind of, a lot of these things are basically solving the problem of balance of power. You know, it's very easy for the government to be vindictive. So they put the burden on the government to prove it's not. Just to kind of to help out. Okay, so these were the 4 charges that they brought against her. And so we said that all of the following charges be discharged nunc pro tunc. That means from the beginning. Okay? And immediately, without delay, in the interest of justice, and with prejudice. With prejudice means that they cannot come back and revive those charges. With prejudice means with prejudgment. That's the idea of with prejudice. So they have to just counts 1, 2, 3, and 4. Further, it's ordered that the defendant be released immediately without delay and with full restoration of lawful liberty. Further, if the above order is not obeyed, then no later than Wednesday, June 6, 2005, you shall show cause to this court why this order should not take effect or should be modified, or why you should not be held in civil contempt, criminal contempt, or misdemeanor contempt of court. Those are the 3 kinds of contempt in California. Okay, so now I want you to notice something here, and that is that we've given them the order, but then we gave them an alternative. We said, all right, if you don't obey this, then you got to tell us why. Show us a reason why you have not obeyed it. Okay? They didn't obey the order, and they did not come back and show us why they did not obey it. Now they're in contempt of court. And so we've brought contempt charges against them. Okay? We've since had a hearing on the contempt charges, and our friendly judge stood on the bench and, of course, dismissed all those charges against them. However, it's Aurora's court, and we'll simply issue a writ of error, vacating it.
Which one of the three?
Oh, although there's three, you see, this is the aggressive side of things. When you get to the actual judgment side, then we'll probably just go for contempt. We'll stay away from criminal contempt or misdemeanor contempt. You always want to err on the side of softness, okay? You always want to look like you're reasonable. We don't have our power position solidified enough to be unreasonable. All right? The judges do. That's why they're unreasonable. They don't care, but we care. Okay. All right. The court, mindful of the rights of the parties and the importance of fair play, will liberally construe the arguments presented. Then we say, this order is not a motion or moving paper, but an order from the above entitled Superior Court, and so forth. Okay? That's what judges do. They'll take your paperwork and say, oh, well, this motion is denied. They'll call your order a motion. If nobody objects, that's what it'll be. Well, it wasn't a motion. It's an order. We had a guy in court one time. He was in front of the judge, and the judge tried that trick. He says, your motion is denied. Oh, I think, no, the judge said, I have your motion before me. And the person said, that's not a motion, Your Honor. That's an order from my court to your court. Well, that stopped the judge there. I mean, once in a while you find judges that do respect it. I mean, they'll test you. They will test you. They'll try different things with you, but you have to be on top of your case and be ready to assert yourself. It's just like that guy I told you about a few minutes ago, I think. He was in front of a court, happened about a month ago. I think in Arkansas is where this took place. And the story, as I get it, was that the judge said something, whatever. He made a ruling. And the plaintiff was standing in front of the judge, and the plaintiff said, well, you're overruled by the court. That judge didn't say a word. Okay. Okay. The thing that I want you to know is that whenever you issue an order, always, always, always have an alternative. If you're not going to obey the order, show why. That's the show cause order. It's also known as an alternative order because you have alternatives. You're telling the person you can do either one. Either obey the order or obey the other order, which is ordering you to explain why you didn't obey the first order. Okay? So that's the alternative. Obey it or explain it. Explain the disobedience. And I think this is what's been keeping our people out of trouble. Because if you just issue an order, you're now presenting yourself as the court. But if you issue an order presenting yourself as the court, but saying, hey, let me know if I'm wrong, well, that's a different game. So this is what we've been doing as a policy. Whenever we issue an order, even the final judgment, you'll see when we get to the final judgment, we said to them, you got so many days to let us know why this judgment is not valid, or to ask for reconsideration of the judgment. Okay? It's worked so far. At least nobody went to jail for that reason. But anyway, the people of California have the prerogative of claiming sovereign immunity. Okay, Note 5 says, people of the state do not yield their sovereignty to the agencies which serve them. Okay? In cases such as this one, this extraordinary attack by the state of California and others against one of the people of California, Aurora Bautista Quicho, requires this atypical method of dealing with the charges. Aurora Bautista Quicho is sui juris and not represented by attorney as imposed and assumed over the objections of Aurora Bautista Quicho by the judges and others of the Superior Court of the County of Los Angeles, case number, so forth. The status of the people of California as the sovereigns of the state of California is a non-justiciable political question upon which the California courts and the district attorney may not trespass. And then again, the people do not yield their sovereignty. Okay? People can be either singular or plural. Just a little note there, footnote 4. Okay? So it's correct English to say a people. No disrespect is intended toward the judges of the Superior Court of California, for they are the mirror of the sovereign people of California, the people's agents. Okay? The mirror. This is from Blackstone's commentaries. I guess Article 270, Chapter 7, Section 379. It says in Blackstone's commentaries, his judges are the mirror by which the king's image is reflected. The judges are not supposed to be neutral. I know we hear that all the time, but they're not. The judges represent the sovereignty. They're there to protect the sovereignty. Okay, to make sure things go the way the sovereign wants them to go. Okay, in the past, Aurora Bautista Quicha successfully asserted her status as a people of California and expects that her wish and will as one of the people of California be respected and acknowledged. This is our system of justice. It must be respected, though you may not personally agree. The judges and officers of the Superior Court and the District Attorney's Office do not have the same status as enjoyed by the people of California. They are persons as defined in the Penal Code and subject to Penal Code Sections 37 and 38. And that says, treason against this state consists only in levying war against it, adhering to its enemies, or giving them aid and comfort, and can be committed only by persons owing allegiance to the state. And so on. We get into a little bit of treason there. They both owe allegiance to the state, the people of California. There is no qualified immunity for those persons who misbehave in this case. Quicho is one of the people of California. The people of California are the state. If a person, not one of the people, as defined in the Penal Code, comes before an inferior superior court, which is neither acting as a court of record nor proceeding according to the common law, the judge has two primary functions, magistrate and tribunal. When a sovereign people of California is in her court of record of general jurisdiction, as in this court, as is this case, she assumes the mantle of the tribunal independent of the magistrate. The judge's role in the proceedings is limited to that of a magistrate authorized only to dismiss the inferior court's case with prejudice. Because we gave him an order telling him to dismiss the inferior court with prejudice. So that's his only authority. It was granted by the sovereign. Otherwise, he couldn't even do that. See? So, okay, so we define what a court of record is. At least the judicial power of this state is vested in the Supreme Court, courts of appeal, superior courts, and municipal courts, all of which are courts of record. So we're objecting to them. The inferior court is not really a court of record, and it's not proceeding according to the common law, which is required for a court of record. And here we get into all this stuff about it. Court of record may not be in name only. Okay, has to act like a court of record. So, anybody want to take a break? Okay. I suggest that we make it a real break.
On your sign here, with the hand of the government turning you in a position where you can't really protect yourself.
Yeah.
Taking all your money.
Sure. Yeah, that's kind of a cute thing I came across on the internet. Yeah, last time we took a break, it turned into a lunch break, which is fine. It was lunchtime. It's now 5:17. Is it dinner break time? Yeah. And we're okay. So we took over an hour last time. Should we limit it to an hour, or you want to make it less?
Hours.
Okay.
How late are we going to?
9 o'clock. Okay.
Hold it, Bill. Before we get out of here, on this green book, The Plot Against Christianity, which is, of course, your introduction to the Talmud.
Where do we get it?
I have 4 more books with me today, and they're 20 20 bucks a piece through me, and they're 25 if you buy them from my source. But he gives me a break because I do order 5 at a time, and I would imagine with the few people I deal with, I probably put out 50 of those books. Oh, okay. And I will say this, that you're going to find in there, I think it's on page 55, wasn't that where I read last week, about withholding taxes out of the Talmud, you know, and this document is a couple of thousand years old, and it was before, this is the stuff that Jesus was, of course, exposing, and you'll find the medical profession, how it hates you. What?
We're not just looking at the screen. Look there.
With this? All right. Well, anyway, you'll find your political, you'll find your medical, you'll find your taxation, you'll find the hatred that they have for you. You'll find out the extreme hatred they had for Jesus. They brag about crucifying him 5 different ways. You know, you'll read about the 5 deaths. And when you can understand that God is a magistrate, you don't have to take my word for it. How many of you here use Strong's Concordance? All right, several. All you need to do is look up the word God, and it's the word theo, and it translates magistrate. There's 2 other definitions. One is a deity, and the other is a supreme being. Now, I'm going to put this in your mind because I'm a brainwasher just like everybody else. If I ask everyone here to write down what a deity means to them, I'd get 30 different answers. Because it's all a matter of what your theologian brainwashed your butt into believing. And if I asked you what the supreme being was, I would get 30 other answers. But if I asked you what a magistrate was, I'd get 30 answers of that bastard on the bench. Now, when the writers of the Bible said the word theo, they were talking about the guy on the bench. But when the Catholic Church and King George or James or Fred, whoever those dick-starved bastards were, gave us our English Bible, they said, oh, everywhere theo appears, we're going to say that's God, and then we're going to have our theologians that study our theology to tell everybody that that's that thing out there in the Pleiades, and so you can believe whatever you want to believe after you start doing some of those studies. But the Talmud, there's a friend that I have, a guy named John Makoviak or something. Yeah, he's Polish or something, and you can never pronounce their names. But he reported to me that in Portland, Oregon, the mayor, I believe it was, or the governor, I can't remember which it was, John was here to clarify that, but the guy took his oath of office on the Talmud. So let's not say it's not a modern day book. Don't let it deceive you by references to the Jews, because that's no more than like my little car club, the Charioteers of Southgate. They've always had to have the shill. They always had to have something to keep your eye off the ball. So, with that in mind, I'll let you guys get off to your...
Let's get a shot at it.
Oh, you want to... yeah, I wish I'd have brought this guy's phone number. The Plot Against Christianity by Elizabeth Dilling. And I would imagine if you give my name there, just tell him Rotten Ron told me to call you up. He'd probably sell it to you for 20 bucks, but it's also, you know, it got a little shipping in there. But
You keep changing it. Okay, so, all right, here we are in dealing with court of record, I guess, on here. Where are we? We're on the order for discharge. Basically, what she did was she issued an order from her court to their court. Her court's the superior court, their court's the inferior court. And so they've already admitted they had no jurisdiction. So in this order, we explain all that. So this order is just tells them to back off, to dismiss the case with prejudice, meaning it's prejudged and they cannot then revive the case later. Okay? If they do, it would be double jeopardy. So where shall we pick up here? It's loaded with footnotes there. All right, here's where we were. They were neither acting as a court of record nor proceeding according to the common law, so the judge had two primary functions, namely as a magistrate and a tribunal in the inferior court. So when a sovereign people of California is in her court of record of general jurisdiction, as in this court, as is this case, she assumes the mantle of the tribunal independent of the magistrate. So the judge's role in the proceedings is limited to that of a magistrate authorized only to dismiss the inferior court's case with prejudice. And the reason he has that authority is because he's been ordered to do so by the superior court. So, yep, the mic's on. Okay, so going down further, the people of California expect judicial integrity from those who sit on the bench as their mirror image. It is the judge's duty, obligation, and responsibility to do the wish and will of the people of California. Likewise, the district attorney has no constitutional authority to charge those with the status of the people of California with penal code offenses in a court not of record and not nisi prius. And we explain what nisi prius means. Okay, right here. It says a nisi prius court is a court not of record which will proceed by assumed agreement unless a party objects. Okay. In the above entitled court, all of the served counter-defendants either demurred or defaulted. No facts are in controversy. This case turned on a single question of law. Did the defendant actors have jurisdiction? The facts presented to the court show that none of the defendants was injured. There is no corpus delicti. Further, the subsequent courts involved were shown to lack jurisdiction. Thus, they were courts of inferior jurisdiction, even though they were otherwise courts of general jurisdiction. And so we have, like, Note 17 says, inferior courts are those whose jurisdiction is limited and special and whose proceedings are not according to the course of the common law. Okay? And then we have courts of general jurisdiction. It goes into, again, what we explained before, the difference between an inferior court and a superior court. So the bottom line is we go through all this explanation, all these footnotes describe the various laws, and we're basically saying that they have no jurisdiction. Now, one of the things that they have done in the past when we've done this is the court has said that these orders are trifles. And there is a legal maxim which says the court does not, the law disregards trifles. Okay? We're not going to pay attention to your lawsuit if you're going to sue for 10 cents. Okay? It's just not worth the effort. And so they'll try to minimize the nature of these orders. So we dealt with that here. We say the law disregards trifles. The Civil Code, Section 3533. The Civil Code, the Section 3533, plus or minus a few sections, those all deal with maxims, legal maxims. So they're not hard-coded law. What they are is general principles, but they're very useful because they do have these little principles in them. Okay, this order to dismiss is not a trifle, and any objection by the district attorney's office to defendant's order to dismiss this case in her proclamation of sovereignty shall be overruled. He has no authority to object to it. Oh, here's a good one. But where the question on note 21 is interesting, where the question upon which the jurisdiction depends is one of law purely, the jurisdiction over the subject matter is always open to collateral inquiry. Collateral inquiry means that you can go on another trial court, particularly a court of record, and attack whatever's going on in the inferior court. So the two courts are trial courts, even though one is slightly superior and the other is inferior. But that's a collateral attack. In comparison, you would have, if you're challenging the decision or the proceedings of a superior court, you would have to go to the appellate court to attack it. See? Whereas in inferior court, you can attack the inferior court from a superior court. And they're both trial courts, as opposed to one being a trial court and the other being an appellate court.
Bill?
So, yes. Got a question?
I was going to ask you, would trifles be considered like when they say this is frivolous?
Yeah.
That's
That's
the
what
same
we're
thing?
talking about. Just,
Okay.
you know.
Hello. Okay, thanks.
So here's some more case law that's interesting. A court of record may not be in name only. Further, keeping a record alone is not sufficient to qualify as a court of record. Among other requirements, the court of record must be proceeding according to the common law. Okay, so these are all these laws, you know, that we've read through, these cases and so forth in the law of the case. Now we're applying it here. So California has two distinct legal systems. It has common law of England and Roman civil law. So the common law is the superior law of the people, and the civil law is the special or inferior law of the government agency. So since we're a republic, the law of the people outranks the law of the government. And then we have access to the common law is guaranteed by the U.S. Constitution. Okay? And that's the 7th Amendment, where it talks about actions at law. Okay, then we have two constitutions. Well, let's see, where we go. We go and get into whether it's a republic or a democracy. The district attorney, through his deputy district attorney, has charged Aurora Bautista Quicha with felonious acts. Amazingly, despite the fact not one person has been injured or suffered any loss attributable to her, under federal law, she was forcibly carried away and imprisoned against her will. And so we explain the whole story, basically. Yes?
I'm sorry to interrupt. Someone needs to be in charge of the hearing condition decisions.
Sure.
Because, you know, I have different appeals come over, somebody tells me, I had an individual
Sure.
a few minutes ago come over and said, turn it on. Now I have somebody else says, turn it off.
Sure.
So, can we make you chairman of that department?
As a matter of fact, earlier we had delegated that duty to somebody back here. Where is he? He's not even sitting there now, is he?
Okay, so he's...
Somebody, I can't remember who.
So should we turn it off?
If he says so,
Okay.
yeah, we'll let him.
So he's the one. One guy. Thank you very much.
Yeah. Well, where is the guy that we're talking about?
He's the one that came to talk to me right now.
Oh, okay. Make him the air conditioning boss. And then we'll all take command of him.
Okay, it's Julian. Okay.
All right. Well, apparently the air conditioning is either on or off, but they can't set the temperature. That's the problem. Okay. So We rehashed the whole case in this particular. Now remember, this is the order from her court to their court, telling them to dismiss. And so we just replay the whole story. And it says, what is this? Good one. What is that all about? First, it's about exceeding jurisdiction against the people of California. Behind that, it is about assuming there's a crime committed without checking the facts. It is about presumption of guilt until proven innocent. It's about refusing to hear the facts. It is about a raw power and rebellion against the sovereignty of the state. By all appearances, the government has declared its independence from the people, so much so that it now appears to regard itself as the guardian and the people as its ward. There is no cause to usurp jurisdiction under color of law. Aurora Bautista Quicha was engaged in a normal business negotiation. Okay? And so on. So this is the story rehashed, as I said before. So we come down here now through all these facts in the story, which you've heard before in the original complaint. Okay? And, we got the law of the case. We repeat all that. Okay? That helped to make it thicker. And then we get by that. And that's all picked up from the original action. Okay? And we explain that. And then finally, we get to the end. Well, that's still the law of the case. I think we put the... Yeah. So the order was at the front, okay? And then the rest of it was supportive. So basically, here's the order right here, right at the front. Comes now the above entitled court of record, a superior court of general jurisdiction, on its own motion and orders as follows: that all barratry shall cease, and all vindictive proceedings shall cease, and all of the following charges be discharged, and so forth. And we order that she be released. And then the alternative: if the above order is not obeyed, then no later than Wednesday, June 6th, you shall show cause this court why this order should not take effect or should be modified, or why it should not be held in civil contempt. So that's the basic principle. Give the order, give an alternative if they disobey the order. Okay? Give a chance to explain themselves. That's the essence of any order that you issue. Okay, so we got that. Now we have, let's see, that was the order for discharge. They didn't do that. So,
Either one? Either option?
neither one. So now they're in contempt of court. Had they come back, they wouldn't have been in contempt. They would have made their arguments as to why we don't have that, see? And we're not lawless ourselves. I mean, if they actually come back with real law showing where we don't have the jurisdiction they do, well, then that's a problem we have to contend with. But we're not just arbitrarily overriding these people. But they never did a thing. So if you give them an opportunity to explain themselves and they don't, you have no choice but to follow through on whatever it is you ordered. So in this case, they're in contempt. So I'll show you two contempts here. We have, all right, we have the contempt motion, BC 12, I believe it is, right here. And we have the order. Let's see. And basically the contempt, we followed the pattern provided by the codes. So the codes really aren't that bad. The real problem always comes from the way the judges exercise their jurisdiction or their discretion. If it weren't for the judges, the codes would be fine. I mean, you look at them, they make sense. You know, there's a sense of propriety as to what makes it, but they just get really arbitrary and just slam people around and literally slam people around. I mean, in the last problem we had, they actually took our process server, who was how old? 73 years old, was she? and slammed her against the wall, tasered her. She had arthritis, you know. A 10-year-old kid would have been a threat against her, you know. And our heroes, yeah, they tasered her. She had marks on her body. She had bruises all over her where they beat her.
What was their excuse?
Well, she must be a threat to society. The judge told them to take her into custody. They took her into custody all right, and they didn't stop there. They actually beat her up. Well, and what did she do? Well, she served the court with an order from the other court. Yeah, so, you know, we are dealing with animals. You know, that's pure and simple. So, but you look at the statutes are fine. You know, I personally see nothing wrong with the codes. I'm happy to incorporate them. And, in fact, I do. I say in my papers, I will decree that this is the law of this case.
I see no problem with shooting wild animals.
Well, that's right, and I think they were wild animals. But no, but seriously, these people are. They appear to be, as we have said in one of our papers, they appear to be an island of law by themselves. The Constitution doesn't matter. The state law doesn't matter. They're going to do whatever they want, and who's to stop them? You know. So. Right, just following orders. Right. The judge issued the order. The judge could hear her screaming. He did nothing to stop him.
Yeah, chased everybody out of the courtroom.
Yeah, no, he just ordered everybody out of the courtroom. That was his solution to all that.
Hey, we had 25 people here. Almost.
24. 24. Unless somebody showed up just now.
I will make a comment on this.
We almost had enough to do our own grand jury.
Yeah,
Just
Bill?
now?
When we got into that courtroom early in the morning, they threw the Quicho witnesses out. Barbara went down to the sheriff and said, hey, this crazy bastard up there is not allowing us to set in on the Quicho case. And a sheriff had to go up there and tell him, hey, this is a public hearing, buttholes. Let these people in. Well, let me tell you what, that infuriated the judge right away. Now, this is early in the morning. Now, we then have the judge leaves the bench. He's gone for about 20 minutes. In the process server tries to deliver some papers to the prosecutor, and the prosecutor standing right there refused to acknowledge that she was being addressed and was being served during a court recess. So the process server dropped the papers over the bar. Bingo, up jumps the bailiff. He runs over and grabs the papers. Fortunately, the server wouldn't take them back. Service had been completed. So he hands them off to Barbara. Well, somehow in the tattletale story, got back to the judge that there had been an altercation out there and somebody was whatever. But see, the judge was already upset that Aurora had a room full of people. We had 11 witnesses, and we even had others that joined in later on. And so he told his goon squad, somebody's going to get in a jam with me today, and whoever it is, I don't care who it is, kick the living shit out of them. Little did we know it was going to be this little lovely old lady, 73 years old, crippled with arthritis, getting beat up and tasered by a gang full of guys. So that's why when I go over to that court, I tell them, I go into the sheriff's office first, you know, I'm here for Quicho. Wow, look out, is it safe today? Yeah, just keep that in mind.
These are the pictures.
Was that the taser one? Yeah.
Yeah, there's where the tasers went into her arm up that top left.
Were these when the gun tasers?
They could have killed her. She was a heart patient. They could have killed her.
Yep.
I tried to tell her, but she didn't pick up on it. I said, she's got a bad heart, but she didn't hear me.
So anyway, we're dealing with, you know, raw, uncontrolled power at this point. So, yeah. Okay. Anyhow, all right. Well, anyhow, these people all demurred, okay, and we dealt with their demurs, and then we issued writs of error. So I'll show you a writ of error here. Let's see. We can go back to the judge. I think this is it right here. Writ of error. Yeah. Okay. All right. This is the writ of error, and same general format. Okay. Versus Y. This rolled over. That's what that Wiley belongs on the right side, not the left side. So maybe I can move that over. Oh, okay. Well, a writ is an order. A writ of error is an order correcting the error. Okay? Cui coram nobis resident. Coram nobis means by us. So this is a writ of error by the very same court that committed the error, as opposed to coram vobis, which is, coram vobis is from a higher court to a lower court. But a coram nobis means by us. The QA, I can't remember what that means, I'm sorry. But the resident means that the king himself was there, the sovereign herself, on the bench. So this is being issued by the king. And most attorneys know writ of error, but hey, you throw these things in once in a while just to confuse them a little. Again, you know, a lot of it's psychological warfare. You know, you throw something in like that, they think, uh-oh, you know something we don't.
Quiet switch, so it's writ of error, which is our court.
Well, yeah. But, okay, the court comes now on its own motion to review the facts, record, and process resulting in the order entitled Order Sustaining Demurrer Without Leave to Amend and Dismissing Defendants, and so forth. See, that was the judge. The judge had issued an order, and now the court is coming on its own motion to correct that issuance of that order. See, what the judge handed the order over to the clerk filed it. The error is that the clerk accepted for filing an order from an unauthorized source. The judge had no authority to issue an order, so the clerk should have turned him down when he entered that order. So we're coming along now on the court on its own motion to fix it. Okay, so on January 10th at 8:30 a.m. in Department 30, the above entitled Court of Record convened to consider a demurrer by counter defendants, the 4 judges. Okay, contrary to the requirements of the Court of Record, the magistrate assumed the mantle of a tribunal and proceeded independently. Now, the magistrate we're talking about here is the one actually sitting on the bench. So we have the 4 judges that had demurred, and now we have the 5th judge on the bench, the judge of our own court, and this judge is issuing orders. So we have to straighten her out. The purpose, let's see, the purpose of this writ is to restore the orderly decorum of the court and to correct defective impromptu process and usurpation of legislative and court powers taken by the magistrate without leave of court. The magistrate did not have any authority to make any new law, had no authority to assume the mantle of a tribunal. In other words, had no authority to do judge things, you know, make decisions. As we have stated before, this court has great admiration for the magistrates. Their training, experience, and wisdom are of great value in guiding this court toward a just resolution of issues. And that's a genuine statement. If these guys would advise the court, that would help a lot. No, they choose to muscle in. we're mindful of the wisdom of Thomas Jefferson when he commented, "We all know that permanent judges acquire esprit de corps. That being known, they are liable to be tempted by bribery, that they are misled by favor, by relationship, by a spirit of party, by devotion to the executive or legislative. That it is better to leave a cause to the decision of cross and pile than to that of a judge biased to one side." Cross and pile means a flip of the coin. They used to have, in the old coins, they had a cross on one side, and I guess, I don't know what a pile is, but it's on the other. Yeah, so you flip, that's cross and pile. So, anyway, it is in part with that inspiration that this court is established as a court of record. Yeah, we're protecting ourselves from these characteristics of judges. So we have 3 sections on this writ of error: judicial cognizance, findings of fact, discussions and conclusions of law, impeachment, and writ. Now, judicial, you have judicial notice. Judicial notice means there are certain facts. These facts can be noticed by the court, and once the court notices the facts, the court can decide whether or not the facts apply in this case. So just because you judicially notice something does not necessarily mean it's going to affect the case. The judicial function is to decide whether or not these factors do or don't affect the case. Judicial cognizance is just like judicial notice, except for one difference, and that is, with judicial cognizance, the judges are bound to obey it. Whatever decisions are made, they cannot contradict these factors that we took judicial cognizance of. So it has to conform. That's different from judicial notice. So we go through the litany of factors, and of course judicial cognizance, basically what we're talking about is the law of the case again. Okay, you're going to see the exact same things we had before. Sovereignty of the state, the people of the state do not yield their sovereignty, and so on, all the way through, down to, I guess, what? Here we define a court of record, and so on. Now we have findings of fact, discussion, and conclusions of law. By the way, if you're in a regular court, if a trial lasts, I think, fewer or less than, I think it's something like 6 hours. Is it 4 hours or 6 hours? I forget what it is. If it lasts less than that amount of time, if you want the judge to write his findings of fact and conclusions of law, in other words, if you want him to explain his decision, you have to ask him to do that before he makes the decision. If you ask for it after he makes a decision, he can ignore you. He doesn't have to explain it. So you have to request that beforehand. If the case lasts longer than those hours, whatever the rules say, then you have something like a couple of days in which to decide you'd like to have an explanation. That's why they want the trials to be short. Okay? So whenever you have a case going in a regular court, be sure to ask for it, and you can put it in as a request. Okay? You can say, request for findings of fact and conclusions of law. Okay? And you just say in simple words that you're putting this request in accordance with rule so-and-so, whatever that rule is. And then he knows that he'll be in a glass fishbowl, and people watch for him, and of course that makes it easier to challenge his decision with appeal or something like that. Okay? So anyway, the record shows that the above entitled court of record, located in Los Angeles, the Honorable Kalin presided over a hearing on January 10th for the purpose of considering the demurrer. Counterplaintiff was not present, but appeared by pleading. And then we have note 4 here. Counterplaintiff personal appearance was prevented by virtue of her being in the custody of the defendants. Okay? So, the record shows using reporter's transcript, hereinafter RT, that the magistrate did not conduct the hearing in accordance with the foundation rules of a court of record. Instead, the magistrate conducted himself as a tribunal in his own court on his own authority, and we cite the reporter's transcript. And without concurrence of all parties, without any supporting authorization from the court. He became a loose cannon acting as a tribunal and imposing his own rules. Without proper authority, the magistrate stepped out of his function as a magistrate and assumed a de facto cloak of a tribunal while sitting as a magistrate. The genius of a court of record is not to be undermined. It is the birthright of every American to settle issues in a court of record, if he so chooses. That choice has been made in this matter and has been so stated in the first paragraph of the action. Further, Article 6, Section 1 of the Constitution for the State of California mandates that all courts of California are courts of record. The magistrate is a person appointed or elected to perform ministerial service in a court of record because all judicial functions in a court of record are reserved to the tribunal, which must be independent of the magistrate. And so we go through, talking about what happened. And let's see. She filed a counterclaim consisting of an action of trespass and trespass on the case for damages. The opening sentence decreed Aurora Bautista Quicho is one of the people of California and in this court of record. ... In counter-defendant's demurrer, there is no objection to counter-plaintiff as one of the people of California, nor is there any objection to the court being a court of record. Nowhere in the record is there any objection from magistrate or counter-defendants regarding this court being a court of record. Further, all parties were properly apprised of counter-plaintiff status and the nature of the court in a counterclaim. It is the design of our systems of jurisprudence that courts have no jurisdiction until a party comes forth and declares a cause needing resolution. The particular jurisdiction depends on how the cause is declared by the plaintiff. Jurisdiction may be administrative, at law, in equity, or in many other formats. In this case, the jurisdiction is at law in a court of record under the sovereign authority of one of the people. It is essential to understand what a sovereign, a magistrate, a court, and a court of record are, and we've been through all that. You know those definitions. Okay? So we'll skip over that. So, who's the magistrate? He's a person appointed or elected to perform ministerial services in a court of record. And note 15, that's Long versus Seabrook, where that came from. Okay? His service is ministerial because you've heard of the administration. That's not the same as management. Administration, all they can do is follow the rules. They have no judgment. Okay? That's why they're called administration. And so ministerial duties are associated with administration. That means they follow the rules. They don't create rules. So his service is ministerial because all judicial functions in a court of record are reserved to the tribunal. And by definition of a court of record, that tribunal must be independent of the magistrate. You notice the repetition that we do? What we're doing is we're linking ideas. You do not state an idea and then assume the person remembers it. Okay? You state the idea. Then in your next sentence, you state the idea again, but you link it to the next idea. Then in the next sentence, you take that second idea and you link it to a third idea. So you create this repeating chain of ideas. That's how you should write these things. So it looks like repetition, but it never allows you to forget. So you have to go down the chain of thought. It's a style of writing that I think helps to keep a person's mind focused when they're reading as to what they're doing. So, by definition of a court of record, the tribunal must be independent. Okay. Non-judicial functions are ministerial because they're absolute, certain, and imperative. Imperative, meaning he has no choice. Got to do it. Whatever it is, involving merely execution of specific duties arising from fixed and designated facts. Okay, then we get into Section 1209. Section 1209 deals with contempt of court. Okay? So what we're doing, this is an order, but we're giving him advance notice that if he strays from his ministerial function, there's going to be contempt. Okay, we do intend to enforce the court's authority. Contempt only has two purposes. The first purpose is to preserve the dignity of the court. And the second purpose is to preserve the authority of the court. So when somebody disobeys the court, that brings in contempt powers. If somebody wants to scream and yell in a court, that upsets the dignity of the court. So then you're entitled to bring in contempt there too. Pardon? I'm sorry?
I just said, is there really dignity there?
Oh, is there really dignity there? That's the question. Yes, there is, actually. At least in my court there is. So we have the magistrate only holds ministerial authority. He holds no tribunal authority and cannot in any way substitute himself as the total equivalent of the court to thus exempt himself from jurisdiction. So section CCP 1209 provides that contempt may be applied to misbehavior in office or other willful neglect or violation of duty by an attorney, counsel, clerk, sheriff, coroner, or other person appointed or elected to perform a judicial or ministerial service. You notice they don't say judge. Isn't that interesting? They don't say judge. They name all the other officers, but when it comes to the judge, they say or other person that's appointed or elected. Okay? Somebody's doing some thinking. My sense of it is that when they write, whoever creates these things, they were on top of it, but they wrote it in such a way, if you're not aware, then you don't see it. But it goes on to say, well, let's see. So he's another person. So we're just letting them know we know the difference. Well, they disobeyed, so later on we have contempt proceedings against these people. Okay, now we get, after we got through all that, now let's see, that section was called the law of the case, not law of the case, but where'd it go? Yeah, findings of fact, discussion, and conclusions of law. Now we'll go to the next thing. That's the impeachment and the writ. The court, having reviewed the facts, the record, and the process by which the ruling was issued, and finding that the magistrate rendered and wrote rulings without leave of court. By the way, the word rendered, that means to speak the decision. So when you go to court, the judge renders his ruling. He just spoke it. Now, watch out, because the judge, when he makes a rendered ruling, is not committed to it. So that happened to one attorney. He went to court, and he won. The judge rendered the decision. So he went home happy. But when he got the actual written order, it was for the other side. Well, what had happened was that the other attorney met with the judge, convinced the judge to reverse his decision, and so now he gets the decision against himself. Okay? So he appealed it. And the basis for his appeal was that, well, he had a commitment. The judge rendered the ruling, you should be able to count on it. The Supreme Court said, nope, if it isn't signed, in writing and signed, there's no commitment. Judge can change it any time he wants, up until the time he actually signs it. So don't think just because you're in front of a judge you won. Okay? It's amazing things that happen. Yep. That's how the game works. Okay. So in finding that the magistrate rendered and wrote rulings without leave of court, and finding that the orderly decorum of the court was replaced by defective, impromptu process and usurpation of legislative and court powers without leave of court. Leave of court means permission of the court. Okay? The judge did not get the permission of the court to do these things. He just decided on his own what the rules were. One of the rules that he made up was he said that, well, judges have absolute immunity. Well, that's not true. I've explained to you the 3 cases where he doesn't, but that's what he said. Okay, that's making up his own law now. Yes, sir.
We have a case going on right now that goes back a few years. They've brought it forward again where we're trying to get the court to come up with that order. In other words, the judge never signed an order. They call it a minute order, which is not an order.
Ah, let me explain. Yeah, right, minute orders. Yeah, let me explain minute orders. Back in the old days, whenever a judgment was issued by the court, it was written in large hand. Large, they wrote large when they wrote, okay? Larger than normal. Minute actually is minute, meaning small, okay? So anything that was produced by the court, like the clerk's notes, those were written in a minute hand, or in other words, small writing. So the big writing was the orders, the small writing was the notes. A minute order is nothing more than a clerk's note, okay? And judges can act as clerks. So that's what they do. They write this thing down. Now, why do they do that? Well, here's the trick. Actually, I don't know why they do that, but this is my theory of what the trick is, okay? But all the California courts are courts of record, right? So right away, you know, constitutionally, since it's court of record, the tribunal cannot issue, the judge cannot act as a tribunal because he's a magistrate. So he gets everybody in front of him. He plays his part. You know, he's up high on the bench. And he gives his opinion, his decision, right? And as long as everybody believes him, that's what's going to be. And then, but if he were to make it an order, he would be violating the definition of a court of record. That would be a constitutional violation. So he makes a note. Call it a minute order. There's no prohibition about making notes. Everybody's there. Everybody agrees. The attorneys don't know the difference. Okay? They accept whatever the judge wants. They're taught in law school that he's a 500-pound gorilla. What do you give a 500-pound gorilla when he demands a banana? You give him the banana, right, or anything he wants. That's what they're taught in law school. So this minute order system works very well for the ignorant. So the judge issues this minute order. Everybody says, oh, it's an order, right? Nobody stops to think what minute means. It means minute, means small. It's the small print note, which is a clerk's note. So it has no genuine force to it, okay? No genuine law backing it up. But they avoid being unconstitutional. That's the game. So, yeah, you were saying you're looking for a minute order. Okay. Do you have a mic? Yeah.
It's not that we're looking for the minute order. In other words, we're demanding to see an order. In other words, Penal Code 526 says that they cannot use a minute order and construe it as an order.
Now we know why, don't we?
Yeah, exactly.
Right.
And so we're trying to get them to produce, to go on with a case.
Sure.
In the beginning, this goes back, like I say, about 5 years, the true order signed by the judge.
Okay, well, it sounds like you might have a lawsuit brewing here. By the way, what section of the Penal Code says that a minute order is?
526.
Oh, it's 526?
California?
Yeah, sure. Well, let's take a look at that order. Okay? We'll go to the reference law books and the California Code, Penal Code. I think we'll find this one. Okay, 526. Okay. Any person who, with intent to obtain from another person any money, article, or personal property or other thing of value, delivers or causes to be delivered to the other person any paper, document, or written, typed or printed form purporting to be an order or other process of a court, or designed or calculated by its writing, typing, or printing, or the arrangement thereof to cause or lead the other person to believe it to be an order or other process of a court, when in fact such paper, document, or written, typed, or printed form is not an order or process of a court, is guilty of a misdemeanor, and each separate delivery of any paper, document, or written, typed, or printed form shall constitute a separate offense. Yeah. So a minute order doesn't specifically say a minute order's, included in it, but that's what it's talking about. Mm-hmm. Okay. Well, let's see. I don't know if I have anything in there about that. There might be in the notes.
Bill?
Yeah.
In an administrative meeting, I always kind of think of it in the context of an administrative meeting where you have a secretary taking the minutes of the meeting and the clerk is acting as sort of like the secretary taking the minutes.
Sure. That is
and that's
the job.
why it's I think of it in those terms of being a minute order as minutes of the meeting.
Except the judge does sign the minute order. So, but the judge is authorized to act as a clerk too.
Well, he doesn't always. I've had some where they're not signed at all, just by the clerk.
Well, yeah, because it's not legitimately in order.
Right.
It's just noting what went on in the courtroom. Okay. Well, let's see. We cover that point, I guess. What else we got here? It says... yeah, right. Okay, the court having reviewed the facts and record and so forth. Yeah. So we go into that. Is that it here? Yeah. All right, so this is where I guess we left. Is that what you're saying? Yeah. Okay, so we had impromptu process. In other words, he was speaking off the cuff. And the orderly decorum of the court was replaced by defective impromptu process. In other words, the judge didn't follow the procedure. He did his own procedure, whatever it is. So that upsets the orderliness of the real court. Usurpation, when you usurp, that means you take over. You take it all for yourself. So he usurped the legislative and court powers without permission of the court. Seneca had a good one right here. Let's go back to that. That's note 17. Here it is. He who decides a case with the other side unheard, though he decide justly, is himself unjust. Now, I intend to use that one on this appellate court where they went in and, the other side never answered. As far as I know, we never heard from the other side when we put in this motion for mandamus. And here the judges come out with a decision. Well, Seneca, when did he come? He was how many years before Christ? A couple hundred at least, or 500? I don't know. So anyway, he's a very respected philosopher. Okay, so the court, am I in the right place here? Yeah. So, and finding that the clerk of the court improperly accepted for filing an order from the magistrate without leave of court, and desiring that fair justice be served for all parties, counter-defendants as well as counter-plaintiff, now therefore the court issues this writ of error, cui coram nobis, to wit, the court impeaches and rescinds the order entitled Order Sustaining Demurrer without leave to amend and dismissing defendants John Wiley, Arnold, Nelson, and Sokoloff, and filed on such a date, and a copy of the first page of which is attached to this writ. And by the way, we took the cover sheet of the judge's order, and we made a copy of it, and we printed in red letters across the face of it, big, from one corner to the next. It said, rescinded. Okay? And the word rescinded means that that order is no good from the day it was created. Okay? So, and then we made a copy of that and attached it to this order so there's no confusion about which order we're talking about. Okay? All right, now, as I've said before, we issued the order. Now the next step is to provide an alternative to the order. Okay? It says, further, the magistrate, counter-plaintiff, and counter-defendants are each invited to file and serve on all other interested parties and magistrate a brief no later than April 24th, 2005, to show cause to this court why this order should not take effect or should be modified. Unless requested, there will be no oral argument. The court, mindful of the rights and so forth. Okay? No oral argument. You don't have to have oral argument. All of your arguments are in your paperwork. By the time you get to the hearing, the only one entitled to speak at the hearing is the court itself. The court asks the questions, if there's any questions. If there's no questions, then there's no hearing. Okay, and then this was signed, then sealed, and then delivered. Okay, so that was the writ of error. Okay, well, that's the... Okay, the judgment. We had a judgment here. Let's go to the judgment. Where is it? It's up here somewhere. Here it is. So, the judgment is basically we have an introduction. Now, one of the duties of every court is to determine whether or not it has jurisdiction. So in this particular judgment, we go into the whole subject of why it is that Aurora's court has jurisdiction to make this judgment. And this is the most heavily footnoted section of the entire paper. Okay? Then we go into the facts of the case, the conclusions of law, the actual judgment, and then an opportunity for them to request the court to reconsider its judgment. Again, we don't assume we're absolutely right. If you got anything to enlighten the court, to tell us why we're wrong, we want to hear from you. We never heard from them. Okay. All of the served counter defendants have either demurred or defaulted. No facts are in controversy. See Note 1. Okay? Demur in pleading. The demurrer admits the facts and refers the law arising thereon to the court. In other words, the facts are settled. All we want to argue about is the law. That's the demurrer. All that remains is to refer the law arising thereon to the court. You notice the repetition? That's what the footnote says. That's what do we say. This case turns on a single question of law. Do the defendant actors have jurisdiction? The facts presented to the court show that none of the defendants was injured. There is no corpus delicti. Further, the subsequent courts involved were courts of inferior jurisdiction. And then we have a footnote on inferior courts, which we've been through before. Even though they were otherwise courts of general jurisdiction. And we get into, well, you know, not only are you a court, you got to act like a court. You can't just take the name. Further, defendants acknowledge that when jurisdiction was challenged, they ignored the challenge and assumed the jurisdiction without proof. Okay? And now we have a little case cite. No officer can acquire jurisdiction by deciding he has it. The officer, whether judicial or ministerial, decides at his own peril. That's Middleton versus Lowe. This court of record, okay, we go to Note 5, and we explain that the California Constitution requires it to be a court of record. Okay? And we define the 4 characteristics. Well, we say there is, but it's proceeding according to the common law. That's the point made here. So this court of record now proceeds to judgment on the demurrers and judgment on the defaults. Now here's a really interesting aspect of demurrer. You remember that all of the defendants either defaulted or demurred. The important ones all demurred. The unimportant ones defaulted, okay, which is fine. So because they demurred and there was no argument on the facts, okay, everybody's agreeing on the facts, it is now purely the option of the court. It's under Aurora's control. The court can now, once all the demurrers are in, can have a trial, or it can skip the trial and go straight to judgment. For some reason, her court decided to go straight to judgment, which is what we're reading here. And we have the case to support it. We said this court of record, we got note 5 explaining it, now proceeds, we got note 6, it says, where we cite the case, but where the question upon which the jurisdiction depends is one of law purely, the jurisdiction over the subject matter is always open to collateral inquiry. In other words, we can collaterally attack. An inquiry is a lawsuit, okay? And to judgment on the demurrers, note 7, and here it is. A court, after overruling a general demurrer to a complaint on the ground that it does not state a cause of action, may in its discretion enter final judgment on the demurrer. And that's what the judges did. They all said, hey, you failed to state a cause upon which relief can be granted. Now,
At the same token, you allowed them to collaterally attack the law on their behalf. They wanted to collaterally attack it. They didn't do that either.
well, it's a court of record. They can't. They're prohibited from collateral attack. But the demurrer is not a collateral attack. Collateral attack comes from an outside, another court. This was inside the court. They were sued. They're saying, wait a minute, this suit is no good for these legal reasons. We agree all the facts are true, but for these legal reasons, you have no jurisdiction. They're saying we're immune. Well, they're not immune because they didn't meet the criteria for immunity. Okay? So that's the interesting thing. I love it when they demur because now we just go straight to judgment. Okay? Okay. Jurisdiction of this court. The first duty of a court is to determine whether or not it has jurisdiction. The jurisdiction is established by the plaintiff when she claims an injury. Okay? So the court, basically, Mittlord wrote a book on equity pleading. And it says plaintiff established jurisdiction when she averred that the acts complained of are contrary to law and tend to the injury of the plaintiff. Okay? And she has not a complete remedy without the assistance of the court. Aurora has no complete remedy without the assistance of the court. That's why she has a lawsuit going. That's all you're doing with a lawsuit. You know, back in the old days, it was very simple. Yeah, well, possibly the good old days. I'm talking about a few hundred years ago. And you just went out and you grabbed the other person who'd done you wrong. You just got even, right? That was your lawsuit. Later on, they put some restrictions on it. And the way it worked was that you took your case to the king or to the nobleman if you were in the nobleman's court. And you got the agreement. You presented your evidence, and you got the agreement that the king would say, yeah, you're right. Once the king agreed that you were right, you were now automatically free to go out and enforce your own judgment. You were your own cop, and you went out and you collected the property by force because you had the judgment. Okay. Now in modern times, we've eliminated that. Only the sheriff is allowed to go out and use force to collect on a judgment. Okay? If you can do it peacefully, fine. But if you have to use force, you call the judgment. You call him, and you have the sheriff do it. Okay, so the jurisdiction is established by the plaintiff when she claims an injury, selects the form, serves the defendants, and the defendants make personal appearances. Jurisdiction is the authority by which courts take cognizance and decide cases. This authority comes from the sovereign people of California who do not yield their sovereignty to the agencies which serve them. All of this is footnoted, okay, to support it. In the counterclaim, plaintiff asserted without objection that she is one of the people of California and that her selected form is a court of record. The defendants were duly served. Defendants personally appeared before the court by attorneys and general demurrers or defaulted. This court comes now to enter final judgment on the demurrers, final judgment on the defaults, and to order defendants and magistrate to show cause, if any there be, why these judgments should be rescinded or modified. And they never did respond. This court concludes that because of the plaintiff's status as a people, her counterclaim, re-injury, trespass, and trespass on the case, the defendants were properly served and the defendants personally appeared in this action or defaulted, this court has jurisdiction over the subject matter and in personam. That's how we decide that we have. So that was very important. That's, like I said, that's heavily, you notice it has lots of footnotes. You know, look at this. We got 2/3 of the page, or actually 3/4 of the page is footnotes on those pages. We just slammed real hard on that. And like I said, we not got a peep from the opposition. And that's what you do. When you're writing your cases, whatever you're doing, you got to make sure that you close off all the loopholes. And that's what I think we did here. All I know is they never objected. I mean, what excuse can they give when you give them full notice and they just don't say anything? They can't say they didn't know because we have proofs of service where we served them. Anyway, the facts, you all know the facts because we've dealt with that.
You've had full notice. They don't give a damn.
Well, that's right. Yeah, we have full notice. They don't give a damn. Yep. And then we have the conclusions of law. Okay? The law of the case is decreed in the counterclaim, and judicial cognizance is taken within the several writs of error unfiled. Therefore, the law of the case is applied herein. It now falls upon this court to apply the law to facts germane to the claim. The principal issue before this court of record is whether or not the defendants, each of them, and their courts, because each of them have their own court, right, acquired proper jurisdiction over the plaintiff. If they acquired proper jurisdiction, then the plaintiff has no case. On the other hand, if there is no jurisdiction, the defendants, by their acts, each of them has acquired an obligation to the plaintiff. The sovereign people of the state of California established the state constitution, 1879. California legislature twice admonishes through the California Government Code that the people of the state do not yield their sovereignty to the agencies which serve them. The people insist on retaining control over the instruments they have created. That implies that the instruments, agencies they have created may not control the people. California Constitution mandates that all California courts are courts of record. One of the 5 characteristics of a court of record is that it is proceeding according to the course of the common law. A California Superior Court is a fully empowered court with unlimited jurisdiction proceeding according to the course of common law. A court proceeding under any other direction is a nisi prius or inferior court. The only inherent difference ordinarily recognized between superior and inferior courts is that there is a presumption in favor of the validity of the judgments of the former, none in favor of those of the latter, and that a superior court may be shown not to have had power to render a particular judgment by reference to its record. But when a court acts by virtue of a special statute conferring jurisdiction in a certain class of cases, it is a court of inferior or limited jurisdiction for the, no matter what its ordinary status may be. See, asserted their jurisdiction over one of the people of California. In this case, there is no authority for the public servants to take command of the sovereignty of the state. Every person who heard and ignored the objections and failed to inquire further and failed to change his behavior must answer for the injury to the plaintiff. This is especially so when none of the defendants suffered no injury. I think, huh? Well, yeah, that would be ideal.
What would constitute them providing that they...
It's quite another to go to a completely different legal system without you agreeing to it.
This brings back this.
Yeah.
Okay.
If you fail to object, then you agree. Let's take a quick look at nisi prius here. Okay? We'll go to the law notes and the foundation, and we have court of record and we have nisi prius court. And so here basically says, okay, nisi prius is allowed, or the objection is to act in excess of the limits of the special jurisdiction. The court may